the one hand, I have to mention here for hard sale mistake. It is negative by your second round of it is drawn on last Friday, 28. During the return favor, a
Work order.
And they be taken out to 2 p.m. later. But in item number 44, I have accident in opposition. In a counter, I will be allowed to call. Okay, for the listing for the listing of it. Under the goes. In item number 66 of supplementary expenses, we will file one entity that will be cost.
Mosul? No. Admission not possible. What is the matter? Matter? That I also know. What matter is that? Huh? Okay, 15. Item number 15. Yes, what is it? What do you want?
I will be allowed to.
Item number 15. What's your name? Mr. B. Sohoria, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated. When is it? Your name? Mr. P.J. Doctor, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the writ petition. So, taking into account the above, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Item number 9, 10, 11, and 12. That's why I'm instructing the petition. Item number 9, 10, 11, and 12.
Why?
That's the petition in this case expired. This is certificate of it. And I have contacted the legal association or expired to get substituted.
Mr. H. Mutunda, the learned counsel appearing on behalf of the submits on behalf of the learned counsel submits that the petitioner had expired on
13/9/2024.
13/9/2024.
30 September
30/9/2024. He further submits that he has contacted the legal representatives who do not wish to further proceed with the instant proceedings. Taking into account the above, the instant writ petition stands closed as it has debated. It was 9, 10, 11, and 12. So, Beleg orders. Yes. Motion? Wednesday?
Supplementary item 56 is there, 10:30 a.m.
The payment has been further released. Now subject to further pay in the bank account.
You have not provided the bank.
Bank account. They don't have bank account.
Then how will you get the money?
I just go before the deputy commissioner and disclose their identity before the registry.
But no government money can go. without bank account.
When you open the bank account, you approach. You haven't received from revenue department, but DC has adjusted the fund sheet for the part.
How many people are you?
Five. Two died, the three immediately.
But it's, madam, it's very strange. Nowadays, everybody has a bank account.
I know, madam. I tried to contact the person, somebody is, someone has account, father, there's some confusion. Let them identify themselves, what is their bank account number.
Pursuant to the orders passed by this court, Ms. Yudas, the learned additional senior government advocate, submits a place before this court an instruction dated 1/12/2025, issued by the District Commissioner Dhubri, wherein the amount payable to the petitioners to the tune of rupees 21,50,118 is now shown to be available with the District Commissioner Dhubri for onward payment to the petitioners. Full stop. The learned senior government, additional senior government advocate further submitted that upon submission of the bank accounts of the respective petitioners,
As well as NOP is also. NOP.
and as well as, why do you need the NOKs? Somebody died,
Yes.
as well as the NOKs, comma, the said amount could be disbursed to the petitioner. So, taking into account the above, the instant writ petition therefore stands disposed of with the following observations and directions. The respondent, the District Commissioner Dhubri is directed to disburse the amount due to the petitioner upon providing the bank details as well as the NOK. The said payment shall be made within 7 days from the date of providing the particulars as mentioned above. Number 3, there shall be no accruing of the interest on the award in question, taking into account that the respondent have already taking into account that the amounts are ready to be disbursed, and it is only upon furnishing of the particulars as above mentioned, the said amount will be disbursed. The instruction so placed is kept on record and marked with the letter Z.
Okay.
Motion item 1.
You became devoter when? 1991. 1991, you cannot be a devoter, taking into account devoter comes into existence in 1997. Isn't it? It happened after the intensive revision carried out on 4/12/1997. So your facts are wrong, Mr. Counsel. You couldn't have been a D-voter.
As per my instructions, it already been declared.
See, we impose a cost upon you for making a false statement before this court. But you are not aware. You are very much aware now this has happened. First of all, you come up before this court saying that you are a D-voter in the year 1991, which itself is a false, because the D-voter concept never arose in 1991.
They've also appeared at my written statement. They've also contested.
And you contested. My goodness. Huh? We impose a cost upon you for filing false cases before this court. How can you be the voter? See, these are all handwritten D. In the certificate copy, you have put page 20. See, it couldn't have been possible. From 2004 till 2021, I was the standing counsel of ECI. So therefore, I know every aspect. The handwritten D. Handwritten D. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. You appear for NRC, na? And you say only NRC will do. So-and-so appears for the NRC. NRC? Okay. And Miss So-and-so appears for the ECI. The petitioners herein have approached this court seeking directions upon the respondent number 6 to remove the alphabet D put in their names in the voters list. The case of the petitioners herein is that they have been marked with the letter D in the year 1991. It is the opinion of this court that the said aspect, that the said averment, the said stand of the petitioner is on the face of it incorrect, taking into account that the aspect pertaining to putting D as a aspect pertaining to putting marking a voter as a doubtful voter arose in the year 1997. Apart from that, Ms. So-and-so appearing on behalf of the ECI, Election Commission of India, have placed before this court an instruction dated 17/11/2025, wherein both the petitioners have been against both the petitioners. There were foreigners tribunal cases, and both the petitioners have been declared as foreigners by foreigners. It is relevant to take note of that in respect to the petitioner number 1, the relevant case number is FT/D 571/2016, and the opinion was rendered on 29/5/2017. In the case of the petitioner number 2, the relevant case number is FT/D 572/2016, and the opinion was rendered on 25/7/2017. The instructions so placed by Ms. So-and-so appearing on behalf of the Election Commission of India is kept on record and marked with the letter X. A copy of the instruction has also been provided to the learned counsel appearing on behalf of the petition. Taking into account the above, the instant writ petition not only lacks merit, but does not also appear to be bona fide, for which the writ petition stands dismissed.
Item 2.
You started the day for all other councils very badly today. Apologies to the councils. Yes, what is your case? Electrocution. Electrocution is not this bench, but anyways, just come. Who died when? Issue notice making it. You are entitled to 4 lakhs as per regulation 5, which is. Huh? Now that I will ask. Issue notice making it returnable on 28/1/2026. Mr. R.R. Gogoi accepts notice on behalf of the respondent numbers 1, 2, 3, and 4. Ms. U. Das accepts notice on behalf of the respondent number 5. Extra copies of the writ petition will be furnished to the respective councils by tomorrow. The case of the petitioner herein is that her husband expired on account of electrocution on 17 or 18 arrival at the dead house on 18 na? At least come to page 24. Expired on 17/1/2023. On account of electrocution, expired on 17/1/2023. The petitioner thereupon sought for compensation from the APDCL authorities. However, the said amount have not been paid, and it is under such circumstances the petitioner has approached this court. Ms. U. Das, the learned additional senior government advocate who appears on behalf of the respondent number 5, shall inform the respondent number 5 to bring on record to place the electrical accident report on or before the next date without fail.
Three.
What is this? Higher charges. How much?
20,65,470.
Itu koi dibo? 23rd of February, affidavit by 16th.
My brother is for 3 months.
Whoever wants to appear for whom, give your details.
Item 4.
Filing affidavit is on 16th of February. They are to, you have, next date is on 23rd of February, 2026.
Item 4.
What is this? Same date. Okay, give your details to him, for whom you will appear. And if it is a government, you are appearing, no? Other? It is 23 or 16. Directing AR so and so to grant arms license forthwith to the petitioner. What is the, why do you need an arm license? Huh? Did you apply? What happened? You applied on 1/3/2024. Bona fide citizen is government recognized journalist. A journalist, what is it? You are to use your pen and now you want to use a gun. What is this? On this ground only it should be rejected. What do you say, madam? Huh?
That instruction, Madam Gandhi, is verbally stated that he often receives threats over.
What? Okay, says valuable wealth that is out, no any criminal records, PSI, so and so. My inquiry of my application of so and so. Submission of so and so, well-known, recognized journalist. The applicant verbally stated that he often receives threat over the phone. You are a journalist working where?
Businessman.
Huh? What journalist are you? In which newspaper? Huh? Newspaper? What newspaper? The first time asking a Dainik Purbodoy in a Hindi newspaper. But where do you stay? Huh? You stay in Borpeta. But the newspaper is in Guwahati and Jorhat. Then what do you do? But what is for a journalist? Okay. There are serious doubts on this aspect.
Businessman, he has multiple shops at Sonpur Colony, journalist.
Huh?
If we call a business journalist, multiple shops at Sonpur, and he verbally stated that he often receives threats from her.
And the authority either accept or refuse the lordship in 60 days they have to pass the sticking order.
Okay, issue notice making it returnable on 7th of January 2026. Ms. Yudas, the learned additional senior government advocate, accepts notice on behalf of all the respondents. Those extra copies of the petition be served upon her by tomorrow. The case of the petitioner herein is aggrieved by the non-consideration of the application for grant of a gun license to the petitioner, an arms license to the petitioner. Though the petitioner applied for the same on 1/3/2024, and there are reports submitted by the various authorities. The respondents are directed to bring on record their stand by filing the affidavit on or before 5/1/2026 as to why the petitioner's application dated 1/3/2024 have not yet been considered. Date of application is 1/3/2024. No, but your application is 1/3. No problem.
Supplementary item 53.
Absolutely, there is nothing in this case. Only on compassionate ground, my lord, because my wife was still she's in She has, kidney transplantation she has undergone.
What do you want here?
Actually, all that I want is let them consider once. They have considered it once rejected. Because of my only on compassionate ground. Otherwise, I don't think I have any right as such. This was particular space was given to me. And I'm also prepared to learn.
So your letter of intent for
Has been
allotment
cancelled.
of land measuring so and so in favor of a unit as have been failed to assess. Your letter of intent has been
Cancelled.
cancelled.
Yes.
When?
On 5.
5?
8 page 37.
Why?
Because my lord, I could not comply with the terms of the LOI.
What are the terms?
My lord, basically some amount was to be deposited and fixed asset value.
2,60,000.
Yes.
Now, what were you required to do?
That your lordship will kindly come to the LOI. At page number 28. Right copy. 24, sorry. Please come to page 25, sir. CN. Page 25, clause CN. Right copy.
Yes.
LOTs shall have to execute a registered land lease agreement for the plot of land with the corporation, agreeing to all terms and conditions for allotment. LOTs shall have to pay the development charge attributable to 1,805 per square kilometer and fixed asset value of 2,60,000 N as indicated in the table above in one installment by bank draft banker check in favor of assets.
How much do you have to pay?
37 lakhs,
37 lakhs.
Yes,
That was issued on 17/3.
yes.
Then
Not, we could not do because my wife was undergoing it on kidney transplantation treatment in Kolkata. That is why I could not.
now you have the money.
Yes, now I am in a position.
The thing is that when they collect the money within 7 days of the expense of LOI, then the timeline is already fixed in the terms and
That's true, my lord. I could not meet the timeline.
Then what I think is that the press notice has already been published.
Huh?
For press notice has already been published for 3 plots of land, which includes this land also.
Where?
That press notice is that, my lord.
Then you submitted a representation
That's what,
that was rejected
that was rejected.
by page 48.
Page 48.
I would like to inform you that this corporation is not in a position to reconsider cancellation of a year for allotment of the land measuring in month, as you have failed to respond to this office reminder dated so and so for complying with the terms and so, and the validity have already expired. Okay, you are giving this LOI how? How did you get the LOI?
Person to tender.
Pursuant to an auction notice.
Yes.
Auction notice is
There was a
dated.
bid, option bid notice at page 21.
What is the date?
13 to 25.
13/2/2025.
Because they can also consider some, enhancement of the value also, having the time gap.
That is very difficult for this court to pass.
That authority will consider. That's why I say, I am not trying to establish.
Where is your last representation after that?
310/25 is at page 43.
Okay, after your cancellation was when? When the
5.
5/8. 5/8, na? Then you submitted a representation on 19/8.
Yes. Thereafter also.
No, no.
without that-
What is this 5/8 you have given? I would like to state that we failed
That
to
was the
comply with them by
representation which has
depositing
been
the so and so, so and so. That's why the initial delay was due to natural calamities that happened from heavy rain and regular fall. Maybe we can need to address on that. Seriousness of it. Mr. Chaudhary, I can do only one thing. You can participate and the cancellation out here shall not bar you or prejudice you. That is the thing I can give you, nothing more. than that. Because if I give here, there is always. What happens there, Mr. Chaudhary, sometimes these orders looks very innocuous here, but these orders later on are taken advantage in some other cases,
cases.
and it becomes very difficult for this.
That's why I said the only compression is now.
So I say that, okay, whatever may be, you agree that if the petitioner participates, you would not prejudice the petitioner in view of this. To dispose it of that. Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. T. Deori, the learned counsel appearing on behalf of the petitioner. Mr. S. Das appears on behalf of the respondent numbers 1, 2, and 3. Respondent number 2 and 3. Ms. Eudas, additional senior government advocate, appears on behalf of the respondent number 1. Taking into account the issue involved, this court issues rule returnable forthwith. The relevant facts which relate, the material facts of the present case are that an auction notice was issued on, what is the date of the auction notice?
13 to 25.
13/2/2025. It couldn't be 13/2 because opening is 12/2. It's 12/2/2025 for leasing out a plot of land at measuring 1892 square meters at the food processing park Soigaon at village Paneri in the district of Kamrup, Assam. The petitioner herein participated in the said auction process and was issued a letter of intent on 17/3/2025. Full stop. Unfortunately, on account of certain natural calamities and the ailment of the wife of one of the directors and another director also of the petitioner company being under treatment, the payment as directed in the notice in the letter of intent dated 17/3/2025 would not be made by the petitioner. Resultantly, on 5/8/2025, the letter of intent was cancelled by the respondent number 2. The petitioner thereupon submitted the representations on various occasions willing thereby informing that the said payments would be made forthwith. However, the same was not considered. In fact, by the communication dated 15/10/2025, the respondents have categorically opined that the respondent number 2 and the 3 have categorically opined that the petitioner's representation cannot be reconsidered. So it is under such circumstances the petitioner has approached this court seeking a direction that the respondent authority should reconsider, taking into account that the petitioner is willing to perform its duties in terms with the letter of intent dated 17/3/2025. Mr. Esdas, the learned counsel appearing on behalf of the respondent number 2 and 3, submitted that the petitioner, that in the meantime, the said land in question, the said plot in question, have already been, in the meantime, an auction bid notice dated, what is the date again?
Date number will be
11th November.
7/11.
Auction notice dated 11th of November 2025 have been issued in respect to various plots of land, including the plot of land wherein the petitioner was earlier issued the letter of intent. Mr. Kane Chaudhary, the learned senior counsel, submits that if the respondents are not willing to reconsider, if the respondents should also not, taking into account the said submission made by Mr. Esdas, the copy of the auction notice has been placed before this court, which is kept on record and marked with the letter X. Upon hearing the learned counsels appearing on behalf of the party, this court inquired with Mr. Esdas, the learned counsel appearing on behalf of the respondent number 2 and 3, as to whether the petitioner herein would be prejudiced, if it prejudice would be as to whether the respondents herein shall, as to whether the cancellation of the letter of intent by the communication dated 5/8/2025 would prejudice the petitioner if the petitioner submits bid in respect to the auction bid notice dated 11/11/2025. Mr. Esdas, the learned counsel appearing on behalf of the respondent number 2 and 3, submits that the auction bid notice shall be decided, evaluated on its own merit without taking into consideration that the petitioner's letter of intent dated 17/3/2025 was cancelled by the communication dated 5/8/2025. Considering the above, it is therefore this court disposes of the instant petition with the following observations and directions. Number 1, this court is not inclined to pass any direction for reconsideration of the case of the petitioner for the purpose of the case of the petitioner in respect to the letter of intent, in respect to the cancellation of the letter of intent dated 17/3/2025. Number 2, it is observed and directed that the petitioner would be at liberty to apply in terms with the fresh auction bid notice dated 11/11/2025. It is observed and directed that the respondent authorities, while carrying out the said auction, evaluating the said auction bid notice, evaluating the auction in respect to the various plots shall not be prejudiced. Shall not. It is further observed that this court observes and directs that the respondents number 2 and 3 shall not observe and direct that the respondents number 2 and 3 shall not take into consideration, shall not be prejudiced by the fact that the petitioner's bid petitioner's letter of intent dated 17/3/2025 was cancelled by the communication dated 5/8/2025 while evaluating the bid process in terms with the auction bid notice dated 11/11/2025.
No, it should be 7/11, because 11 is something relating some other.
Okay, 7/11.
7.
Seven.
There is one more thing, the third is the last date. And to extend the date, you have to submit the bid.
Last date is 3rd.
Third.
You can submit. I can't extend it, very difficult.
Okay. It should be 7/11,
7.
not
We'll
11.
get the order today. I'll just make it properly. The last line I am not getting it properly, so
They
I'll
will
make
not reject my
Bid,
tender on the
on
ground
the
that
basis of that. Now, it is observed and directed that the respondent authority shall not reject the bid of the petitioner. Should the petitioner submit bid in terms with the auction notice dated
7/11.
7/11.
Or at least an item 6, part her. The authority, as per an authority act, against the electricity act, against the work license rule, against the telegraph act. This should be completed by expedition.
What is your basis of your assessment?
The assessment, as the instructions are placed on the previous page, but the district commissioner, the assessment has been made with regard to the applicable circle rate and the proportionate share of the land where the poles have been erected, petitioner's land. There is a report of the circle officer, madam. It says, that is the circle rate as far as the land in question is concerned. Now, based on that circle rate, the assessment has been carried out.
And against that, what is the recourse?
The recourse is under Rule 16 that I showed on the.
Of the
I'm sorry, Rule 15 of the Assam Electricity Workshop Licensing Rule 2019. Has a copy of this.
yes, I've got.
15, determination of dispute or difference by the appropriate commission. Matter is brought to the appropriate commission for determination under the influence of matter shall be determined by the appropriate commission within a period of 30 days after hearing the parties concerned. Now, as far as the determination of compensation is concerned, Rule 13 will apply with us. If the licensee makes default in complying with any of the provisions of these rules, he shall make full compensation for any loss or damage incurred by reason thereof to the person affected, as may be determined by the district magistrate or by the parties. Now that determination.
And if there is a dispute, then by appropriate commission means?
Appropriate commission, is my respectful submission is the ARC.
How do you know?
It has been defined.
Where?
Yes.
Has it been defined?
Section Rule 2D.
Commission means the Assam regulator.
Yes.
Okay, you are aggrieved. No,
No.
Mr. Counselor, you have to understand, this court is not in a position to decide.
Yes, Worship. No. My only submission is that it is not the dispute regarding compensation. If there is a compensation dispute, Worship, if I ask for the compensation dispute, then the alternate remedy is available to me. But I approach before your lordship for the not compliance of the rule and act, Electricity Act, the Electricity Act of 2003 and the rule of work license 2006. Worship, this rule has been come into effect after notification on the 3rd of June 2019. The dispute is even I have filed this in 2017. So this not applied. Even if lordship, the division bench of this honorable court lordship has a similar issue, almost similar facts and circumstances as the issue lordship. And then comes to page 4, favorite question.
Where the working rules? 2006.
Yes, I have given to your worship. Those are part of the act.
No, they are referring to some working rules.
Yes, because the 6 worship, there are 3 worship, section 1. Sorry, group 3.
These are central government rules.
Yes, sir. To carry out work. This English portion is delivered.
Same
3A.
13.2.
3A.
13.2.
Now, 13, I'm not from the worship. What is the rule? What's come to 3A worship?
Huh?
3A worship, page 11.
Yeah.
Carry out works, lay down or place any electric supply line or other works in, through or against any building or on over or under any land whereon over or wherever any electric supply line or works has not already been lawfully laid down or placed by such as such with the prior consent of the owner or occupier of any building or land. So this, our case is, this was not there, and no notice, even no notice is also there. Our now if provided, if no consent has been given, provided that in case where the owner or occupier of the building or the land raises objection in respect of the works to be carried out under this rule, the licensee shall obtain the permission in writing from the district magistrate or the commissioner of police or any other officer authorized by the state government in that behalf. That is also not their worship. So they act against the rules worship.
No, but the fact remains, Mr. Council, you will be entitled to compensation. Now, what will be at the end of the day, it's the compensation, is the question.
We are not asked for the compensation worship. We are asking for the reduction of this court because there is an arbitrariness. When manifest arbitrariness is there, this court has a jurisdiction worship. Even the Supreme Court worship knows. So I have to draw all these things. Because they are violating the rules, the act provisions, and even in the 2019, the work rule, this 3A is there. Even in the 19, this is there. So I'm not disputing the compensation. I am arbitrarily they act against this rule and the act.
But what do you say about 15?
By the appropriate commission when matters brought to the appropriate for determination under this rule.
When a matter is brought to the appropriate commission for determination under these rules.
This is determination worship.
No, this is not for compensation. Compensation is 13.
Or determination.
For determination of what?
Determination of compensation.
No, compensation is 13.
Worship, 13 worship. Determination and payment of compensation. Determination. That word has been used there.
Determination under these rules.
Yes, worship.
The matter shall be heard by the appropriate commission within 30 days.
13 worship.
No. Mr. Council, you have to understand. 13 is for determination of compensation.
Yes.
15 is not for determination of compensation. If there is a dispute,
Dispute regarding compensation. Worship.
no,
Is-
it can't be because
I-
you see, you cannot think that the particular rule or an act has been made superfluous. When 13 categorically deals with determination of compensation, 15 says determination under the rules. Why should we interfere? Look into it.
Worship's approval. Worship. Pay 13 determination and payment. The determination they have to determine and they have to make payment. If we have not satisfied with that determination, then Rule 15 will come.
No. They are to make the payment by themselves.
Yes.
Without making payment, they cannot.
Yes.
But if there is some dispute, you can see where licensee makes default in complying with any of the provision of these rules, he shall make full compensation for any loss or damage incurred by reason thereof. So if there is a default in complying with any of the provisions, means including that without informing you that look here, we are going to put or erect these poles, they have or taking the permission from the DC or for the purpose of taking the permission from the SP, they have done so. So it is a case of determination. They have determined as a compensation for the land value. That is not the question they are to decide. They are to decide what is the loss felt by you. This is what the appropriate commission can do. Why should this court look into it?
I have placed the division bench for our lordships, division bench already lordship held in page lordship, page 5 lordship, that if any support is given to overhead lines by electric use of force and on the land belonging to private party, then in that event, permission of district magistrate or the commissioner of police or any other authority specified by the state government in their behalf has to be obtained. Lordship.
Now, if it is not done, then
So the consequences is their lordship.
If it is not done,
the rule provision has not been followed.
no, if it is not done, therefore 13 comes into the picture.
I mean, only subject lordships.
No, I understood. But here did the authority, did the division bench take into account clause 13, rule 13 of the working rules of the licensing rules? Because the rules categorically say where the licensing means FEDCL, makes default in complying with any of the provisions of these rules, which includes rule 9, rule 3. He shall make full compensation for any loss or damage incurred by reasons thereof to any person affected, as may be determined by the district magistrate or any other officer authorized by the state government in this behalf, and if not agreed mutually between the parties, meaning thereby 13 is for the purpose of district magistrate. Now kindly see the judgment out here. What does it say? The respondents in return so and so, kindly see, in view of the disputed questions of facts can be only tried by the district magistrate concerned or the commissioner of police or any other officer authorized by the state government in their behalf. So long as the dispute is not resolved by the district magistrate, no polls can be constructed. Now, in your case, polls have already been done.
That was done. Those stays of appointing that was done, Lordship, that in violation of the court's order.
The interim order was only not to energize the line. The interim order was to the extent of not to energize the line. If I may also point out one thing, as Myros has pointed out, 13 only deals with the issue of as regards compensation. 13 too, if Myros kindly sees.
Yes.
13 too, it says that if there is any dispute as regards the compensation, the commission can look into it. So 13 is independent. As Myros has rightly pointed out, 15 will decide on all issues, all disputes and differences as far as the rules are concerned. And that lies before the commission. 15 and 13 are not related.
So I think these rules of 2006 have been in verbatim incorporated in that 19. Hello.
The compensation amount as assessed, I have the checks ready, if they are within checks, I can make
And they let them receive it under protest.
That is their concern, Rashid.
Mr. Counsel, I give you the liberty that receive we under protest. Under protest means you can challenge it. Because unnecessarily it makes no sense. You take it, they are under protest. We'll see later on. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary, learned counsel appears on behalf of the petitioners, on behalf of the respondent numbers 2, 3, 4. Miss So-and-so appears for Mr. M. Nath, and his senior counsel Agati assisted by so-and-so, represents number 5. Mr. B. Chaudhary accepts notice, appears on behalf 2, 3, 4, and Miss Yuda accepts, appears on behalf of the respondent number 1 and 6. The petitioners herein are aggrieved by the actions on the part of the respondent authorities in erecting ST electric posts on their respective lands without seeking their permission. Erecting ST electric posts on their respective lands, contrary to the settled principles of law. The facts of the instant case reveals that the petitioner number 1 is the owner. All the 3 petitioners are owners of various plots of land. It is the case of the petitioners that the respondent APTCL have installed ST electric posts in their respective lands by forcefully entering into their respective land and starting construction. It is the further case of the petitioner. The respondent authorities have no authority to install, erect, lay down transmission lines on or over the lands belonging to private persons unless permissions are obtained in compliance with Rule 3(1) of the Works of Licenses, Rules 2006, framed in exercise of the powers under Section 67(2), read with Section 176(2), (e) of the Electricity Act 2003. First, upon filing of the instant writ petition, the records revealed that this court passed an order on 26/7/2017, whereby notice was issued, and till the returnable date, the respondent number 5 was directed not to energize the concerned 11 kV line. The record further reveals that the respondents, anybody has filed affidavit? The records further reveal that no affidavit in the meantime have been filed. When the matter was taken up by this court on 7/8/2025, this court directed the respondents to carry out the assessment as to what amount the petitioners are entitled to and provide an update to this court by the next date fixed. Full stop. In the meantime, the respondents have carried out an assessment, and as per their estimation, the three petitioners are entitled in total to an amount of rupees 23,312, the details of which full stop. This aspect could be apparent from the instruction placed before this court and kept on record and marked with the letter Y. Full stop. In the above, full stop, it was also submitted by Mr. B. Chaudhary, the learned standing counsel of the APDCL, that the respondent authorities have taken steps for making payment of the said amount of rupees so and so to the petitioners, but the petitioners have refused. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties. Now, in the backdrop of the above, let this court now take note of the respective submissions made on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that it is the mandate of Rule 3 of the Works of Licenses Rules 2006 for short, the Rules of 2006, whereby a licensee is only permitted to carry out works of laying down or placing any electric supply line or other works in, through or against any building or on, over or under any land with the prior consent of the owner or the occupier of the building or the land. The learned counsel submitted that the licensee, however, can erect can lay down or place any electric supply line over a private land only after obtaining the permission in writing from the district magistrate or the commissioner of police or any other officer authorized by the state government in that behalf for carrying out the works. It is the learned counsel submitted that in the instant case, the respondent authorities, more particularly the respondent number 226, 225, have taken steps without the consent of the petitioners, as well as without also taking the written permission from the district magistrate or the commissioner of police or any other officer authorized by the state government. The learned counsel therefore submits that the very laying down of electric supply line over the land of the petitioner is absolutely illegal and unauthorized, and therefore appropriate directions is required to be passed. Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL, submits that the question as to whether permission was taken, prior consent was taken from the petitioner or not, is a question of fact which cannot be adjudicated in this present forum. In addition to that, the learned counsel submits that in terms with Rule 13 of the Rules of 2006, such disputes, if any, can be decided by the district magistrate or any other officer authorized by the state government in that behalf. If there is no mutual agreement between the parties. The Learned Counsel further submits that in addition to that, the appropriate commission have been granted the jurisdiction to for making determination under the rules of 2006, which the Learned Counsel for the APDCL further submitted that in the line of the rules of 2006, the state government have also formulated a set of rules which is known as the Assam Electricity Works of Licenses Rules 2019, wherein the provisions are parameterial. This court heard the Learned Counsels appearing on behalf of the parties at length. The question as to whether prior consent of the petitioner was taken or not is a question of fact. In addition to that, it is relevant to take note of Rule 13 of the Rules of 2006, which was holding the field at the time when the dispute between the petitioner and the respondent, APDCL, arose. Rule 13, being relevant, is reproduced hereunder. From a perusal of the above quoted rules, it is seen that if a licensee, that is the APDCL, had committed a default in complying with any of the provisions of the rules of 2006, which also includes Rule 3, the licensee shall be liable to make full compensation for such loss or damage incurred by reason thereof to the person affected. This aspect can be determined by the district magistrate or by any officer authorized by the state government in that behalf, if not agreed mutually between the parties. It is further seen from sub-rule 2 of Rule 13 that if there is a difference and disputes, any differences and disputes arise as regards to the amount of compensation determined in terms with sub-rule 1, the matter may be determined by the appropriate commission. This court further finds it relevant to take note of Rule 15 of the Rules of 2006, which is reproduced hereunder. From a perusal of the above quoted, from a perusal of the Rule 15, it is seen that when a matter is brought to the appropriate commission for determination under the rules of 2006, the matter may be determined by the appropriate commission within a period of 30 days and after hearing the parties concerned. It is also relevant to take note of that in the meantime, while the present proceedings have been going on, the state government had formulated the Assam Electricity Works of Licenses Rules 2019, for short the Rules of 2019, wherein the provisions are parameterial. Wherein the provisions, including Rule 13 and 15, are parameterial. It is further relevant to take note of that Rule 2D defines commission to mean the Assam Electricity Regulatory Commission. So, in view of the above, it is therefore the opinion of this court that from a conjoined reading of Rule 13 and 15, from a conjoined reading of Rule 3, 13 and 15 of the rules of 2006, which is parameter to the rules of 2019, that if there is any violation committed to the mandate of the rules, the respondent, the affected party can seek redressal by way of the affected party. Here, comma. It is the duty of the district magistrate to determine the compensation payable to the affected party for the loss suffered by the affected party. It is also seen that if there is any dispute or differences as regards the amount of compensation determined by the district magistrate, the matter can be decided by the appropriate commission. Under such circumstances, it is therefore the opinion of this court. Now, further to that, taking into account Rule 15, which further empowers the appropriate commission for determination anything under the rules, it is the opinion of this court that the dispute between the petitioners as well as the respondents, numbers 2 to 5, are to be determined by the appropriate commission. Accordingly, the instant with petition therefore stands disposed of with the following observations and directions. The petitioner herein are given 30 days time, are given the liberty to approach the appropriate forum commission, that is the Assam Regulatory, Assam Regulatory Commission, within a period of 30 days from today. Seeking damages for the loss, seeking damages or compensation for the loss suffered by the petitioner in view of the act on the part of the respondent authorities in laying electric supply lines over the land of the petitioners. The appropriate commission, that is the number 2, that is the so and so, shall decide the same disputes in terms with Rule 15 of the rules of 2019 within the period stipulated by giving both the parties an opportunity of hearing. It is further observed that in the circumstance the petitioners are aggrieved by any compensation, what is the remedy available thereafter is the writ petition. Huh? It is not here. With the above, stands disposed.
One suggestion. Appropriate commission as per their notification 2019 is there in the city. But in the rule that is not prescribed. Appropriate commission by this rule, but the appropriate commission has not been defined. So as per my knowledge, it will be that district commissioner will refer to the appropriate commission. That is the prevailing rule at that point of time.
But the appropriate commission has not been defined.
Yes, not
Now,
really
in the
defined,
meantime, the 2019 rules have come in. You see, you have to get your relief faster. We are in 2017. So you need to get your relief faster. I further say one thing. The petitioner hearing are given the liberty to accept the check, the amount tendered without prejudice to their claims, which without prejudice to approaching the appropriate commission as per the liberty hereby given. Because otherwise, what will happen? They will stop the interest. Got money? Haven't got any money?
Finally, the proposal is now being submitted for the pre-order when it was under the signature of the deputy commissioner as well as the superintendent of police, Kasar. Constituency may not landmark number one. Now, refixation may not be done. So the executive agent of the regarding the next part. Constituency may not landmark number two is the minus over there it has been discussed there, but they will be living the building and concentrated of the government will be there are five. And landmark three is another minus where the liability of the various departments also this we have occupied it has been discussed and ultimately it has been decided that they have to perform for the entire.
So when are you vacating?
But that they have decided that any alternative between of the government is available, it will be transferred. So in a sense,
First of all, you are not making payment.
it will be paid, if the rate, we release it will be paid. Now, they are moving the proposal, as the government.
Now, first of all, you see, he has a particular rent rate. You cannot arbitrarily say that we are going to pay you this. There was a further fixation of rate at one point in time. Now you want to say something else, it's a different aspect from that. Whether he gets or not. But the fact remains that if you are not there, it is not that you have to vacate it. You don't have the money.
They are moving the proposal.
No, your proposal has been going on for a long time. We are in the month of December. You said on the last day that I have issued an instruction to Mr. Gogo stating that there is a financial sanction of rupees 40 lakhs
Yes.
against 25 months of rent with effect from so and so to so and so, which has been uploaded in the government portal. But why no payment has been made to the petitioner till now?
There is some discrepancy regarding the fixation of rate. of the rent. So my lord, the executive engineer was against my lord requested. My lord,
No, he will do whatever you ask now. Now, can it be arbitrarily done by yourself later on? You have agreed to a particular rent and now you say that that person concerned is wrong.
So that part also will my lord, let me file the affidavit, my lord, what should we decide on that point? my lord?
Okay,
Whether-
fine. You file the affidavit
Yes,
by
if you
Wednesday.
want to get that, if a order is
You
passed,
file your affidavit by Wednesday and vacate it. You are not going to remain there.
the vacating, no, my
No,
lord.
no, vacate, you have to vacate. No, this is appropriating somebody's property, 300A. It's a gross violation. You have not paid him the rent for all this while from 2019 onwards. You have not paid him the rent. And now you are doing all these things. And they will say that when we find alternative accommodation,
All right, development of. Your my lord, sir.
vacate it.
Also will take about 5 years, the government. Whatever is there.
No, no, no. When are you vacating it? Give us by you. I think you should vacate it by today is first. Today first you should vacate. You vacate it by today. First is good day.
So, my lord, let me file the affidavit on Thursday.
No, no, no. Then who is going to make the payment? You don't have the money.
No, it will be paid, my lord.
First of all, you on your own fix a particular rate.
That I will address, my lord, let it be on my lord Friday.
No, not even Friday. This can't happen like this. You on the last occasion say that a financial sanction has been granted. And this appears to be something wrong. So it seems that your person is not there. So I will call the home secretary, nothing doing. No. This is absolute. What is submission you made on the last occasion is completely contrary to this. First of all, you should have filed the affidavit. Why haven't you filed the affidavit in the meantime?
No, my lord, by today, my lord, by 10:30, I got the affidavit of the
So,
deputy commissioner.
you knew it very well.
During the course of the-
No, you knew it very well. The matter was fixed today. It is not that the matter has come all of a sudden. There is no payment, nothing has been taken.
Regarding affidavit part.
Grant an opportunity to respond to place before this court as to when the possession was handed over to the respondent number 7 by the petitioner of the building and further produce the records pertaining to taking over of the building of the petitioner before this court on the next day.
That lordship will find, my lord, in the third witness in the past. Now they find it that part. It was handed over on 26 August 2019.
Until now, he has not got a single penny.
And my lord, regarding the deputy commissioner, my lord, inspection, my lord, I already prepared the affidavit. I can file it in the course of the, I got it, my lord, at 10:30. Sign it. So I mentioned that.
What is this? This is to certify what is annexure 1, flag 1.
My lord, that is the, my lord,
This is the house rent
land calculation for the.
of 1,22,848.
Yes, now my lord, in the next day, lord, we will
Now,
find, my lord.
now you have a particular. What happened to your this thing, the Tenancy Act? What happened? There was a Tenancy Act which was passed in the cabinet. It has not been brought in, not in the legislature. What happened? There every year there is an increase by 10%. How is it that it can be 1,22,848 stagnant from 2019 onwards? It can't be stagnant. Can it be stagnant?
And in there, my lord, earlier assessment also they have found 3,08,000.
Huh?
Earlier, by the same department, that is, I have annexed my lord, in my experience. So, here you are,
That was, my lord, calculated in a inflation manner, my lord, that is
the
what
subsequent day, it's.
what they have calculated.
You should not have taken it.
I understand, my lord, but whatever is due. that will
Now
be-
also, if you are not in a position, why you are not leaving it? We'll consider how much amount.
It will be, my lord, it will be released, my lord. Only thing is, my lord, they are looking
Fifth.
after it.
Release it.
Yes, we are passing that.
So let them go. Let them go somewhere else.
No, they will go, definitely. go.
When?
Provided they-
First of all, you don't have the money to pay. And if you don't have the money, it is his private property.
minor money part is, I'm not saying that we don't have the money. Only thing was, my lord, the.
If you had the money, if there was a financial sanction, why haven't you paid that money?
Because of this, my lord, refixation of, my lord, the.
Refixation is being done in the year 2025 now, all of a sudden.
They found that because it's stated, my lord, 3 lakh something. Well, I will place an affidavit, let it go. Whatever is there on my list. And my lord, the final, my lord, note of the government, my lord, when they are going to pay the, my lord, whatever is due. Or each, my lord, whatever we have found, it will be paid to the petitioner by what day it will be there. So we will have to move the finance and all. The government, my lord, they got the proposal from the lower authorities, the district authorities.
You already have a financial
So
sanction.
that was one because the refixation was procedure of the process. So that was the only period where my lord it was under the occupancy of the SB. But again, my lord, the deputy commissioner's part is remains from 19 now, my lord, they have calculated the entire irrespective of whether.
And now you come to 48 lakhs,
You know,
46 lakhs.
No, it's 1 crore 22, proceeds is the part of the color calculation part. Four
Yeah.
things.
Yeah.
Four things.
What is it?
Last, fourth page, the last line has monthly house rent will be 1 crore 22, 848.
No, is 1,22,000. What is this?
1 lakh, this is a
Ah.
monthly. One,
You have taken the value of the building
my
on your own, the value of the building, and then you have multiplied by 7.5% divided by 12 is equals to this.
as per the PWC, my lord, calculation.
So who is the PWD to now ascertain that no, we have taken the way on so and then now it is wrong? You can't have that.
It is as per request of the deputy commissioner, it was conducted. The lordship will be paid some like 1 3 various three paragraphs or heads. The liability has been discussed. Here, my lord, from 2019 to 31st March 2020, the payment of house rent for this period shall be made by the political fee branch under the Home and Political Department, Government of Assam. The magistrate branch, EC office, Kasar shall fix the fair revenue conservation with the.
Now you see here it is 1,60,000.
Then final only practice university found earlier defined institution based to be they have that the same department have assisted as to 3,88,000.
They found to be expected. But
Yes,
lodging
you
is
see,
third
I
paragraph.
have connected with them.
That one be third paragraph.
What is it?
Clear from first of April to 23 to till date. Lodging will be the last part. A proposal amounting to rupees 46 plus 61,000.
How rent? See the rent.
Yes, for this particular period, has already been forwarded to the Assam Police Headquarters under the so and the release of the file is under process. And this is the violence of 14 November 2025. There between the deputy commissioner and the. So by 5th November, file was accepted, there is the clear picture whatever is there as on date. Then also take it.
Along with when you are vacating. It cannot be beyond this year. I'm telling you, it cannot be beyond this year. You have to vacate. You don't have the money, don't do it.
They have to connect.
One should cut their cloth as per their capability and not in this manner.
It will be paid, of course, when it is.
No, it will be paid when.
That will be there in the. Place it on my side of the website.
Now, vacating has to be this year. It cannot go beyond this year. I don't have the money, you don't. I hope. Pursuant to the order dated 17/10/2025, Mr. B. Gogoi, the learned additional advocate general, have placed before this court a set of instructions issued by the Assistant Additional District Commissioner Kachar, dated 29/11/2025. The said instructions, however, is contrary to the stand of the respondent authorities, which was submitted on 17/10/2025. What is noticed in the present instructions so placed is that the respondent authorities unilaterally have now refixed the rent without any consultation with the petitioner. It is further relevant to take note of that on 17/10/2025, the learned additional advocate general stated that there is a financial sanction of rupees 40,18,700 made against 25 months of rent with effect from 1/4/2023 to 30/4/2025, which have been uploaded in the government portal. However, from the instructions which is being placed, a completely different picture have been provided. But one aspect is clear from the instructions, that there is a due admission that the petitioner's building have been under the possession of the respondent authorities with effect from 1st of 1/9/2019. It is a trite principle of law. It is well settled that the state cannot appropriate the building, cannot forcefully keep the building without making any payment. Because the present case appears to be of similar like. In the instant case, neither the petitioner have been paid a single penny since 1/9/2019. And the respondent authorities, however, have not given any indication when they are vacating. Considering the above, list this matter again on 12th of December 2025. On the same date, the respondent shall clearly state as to when the respondents would vacate the premises of the petitioner. And it is made clear that under no circumstances the respondents can be permitted to retain the possession of the petitioner premises beyond 31st of December 2025. Under such circumstances, the respondents further to that, on the next day, the respondents, all the respondents in the present proceeding shall intimate as to when the outstanding dues of the petitioner shall be paid. The instructions of place is kept on record and marked with the letter. ABCD position like that. I'll highway example.
There are 9 days, but I feel some type of there are some articles.
What is your case, Mr. Dingia? But didn't they do it by way of an auction, lottery? How did you settle the shops?
Some possibility adopted by them
So the petitioners were earlier carrying on business.
There is a list of 318 persons. And shops are in the ground floor 47, first floor 47, and third floor, and second floor 47.
Same with K. Mojumdar.
Yes, same one.
But how can it be 47 when K. Mojumdar has been given serial number 50?
Possibly in the ground floor 1 to 47, then 48 to 48 and onwards it is first floor.
So you have almost around 150.
100 kilos.
Then
But the list contains the persons of 380. So everybody cannot get. But in the 2014, there was a requisition and the open court directed the executioner to make an inquiry. After the inquiry, some persons have been given. But these petitioners, along with some other persons, those are before the authority. There are some processes going on. I have to get the instruction. I will put some kind of
when?
2 weeks. I will give it 2 weeks.
The list is matter on 17th of December 2025. In the meantime, a final opportunity is given to the Lanka Municipal Board to bring on record their stand by filing the affidavits on or before 15th of December. Interim order passed earlier shall continue.
I got interim order. Interim order was
Mr. Nath,
on 13th.
does it suit you to say anything about the interim order where for the last 2 years you have not filed your affidavit?
But just want to clarify one. Interim order on 13th week and the order says that some shops will be kept back at the ground. In fact, in the
Now there is nothing in the ground floor.
in the ground floor, everything has been filled up in 2022. Because what informed the urban code when the interim order was passed. That is what the right is.
I can't touch it. Was there last direction to interim order assembly?
Yes.
About 5%.
29/4.
Interim order says it is there, so I can't help you. You file your affidavit, you finish it off. Before vacation, we can finish.
Again, 30.
Where is Mr. D.K. Jain?
30.
What is this? Water resource? What is your stand? Huh? You are paying for? Now, what is your case? Oh, there is a requirement of making somebody a party. Okay. It is seen that the petitioner sought for time for implement of the Ministry of Jal Shakti as well as the Brahmaputra Board, taking into account that they are necessary parties, taking into account that the scheme under which the petitioner claims the amount are to be, the payments are to be made under those schemes. However, the petitioner have not implemented the Ministry of Jal Shakti as well as the Brahmaputra Board. The petitioner is also not represented. Taking into account the above, it therefore appears that the petitioner must have lost interest in the instant proceedings. Accordingly, the instant petition therefore stands dismissed for non-prosecution.
16.
Huh?
Outstanding contractual liability in respect of what that is. The PDP has also been admitting the liability.
Admitting.
total amount is 31,62,800.
Okay. Who is the respondent? এখন এফিডেভিটৰ এখন লগাই দি paragraph admit কৰিছে affidavit filed with response number 6 paragraph 5 টো put কৰি দিব paragraph 6 টো put কৰি দিব and paragraph 8 6 months from the date the certified copy is served upon the respondent number whom you have implemented somebody.
Yes, my lord, the deputy commissioner for investment.
Okay, we have to submitting we have to
Is also 25,11,25.
respond number 4 certified copy to respond number 4 of the order should be furnished to whom respond number 4
My lord, 4 and 6.
why you are taking so many people they are admitting the respond number executive or water source have admitted
Orders have been allotted in installment various times. Therefore,
then who is going to pay who no therefore the head of the department will be whom
basically 4 and 6, my lord.
6 is executive engineer I'm not going to direct any executive engineer to pay why haven't you made a chief engineer
Additional chief engineer is also.
chief engineer should have been there okay to respond number 4 of course 6 months
17.
verify to qualify they are therefore entitled to the money 1 or a year to be paid from the date of 6 months so and so it is. Yes, what is this discussion?
Yes, but now 2011, when the meeting was held, the petitioner was present to video conferencing. And some documents were sought for matter from the petitioner. Said that he had some documents to show that matter the vote was allotted to. Now those have been furnished to the PWD authorities. We'll be examining that and we'll be moving the GAD department. So it is the GAD department who has to make the management. PWD is only matter examining the due to the one is due.
How much time?
That part they say by within this week will be forwarded to the
Okay, so
GAD
we have it on
before vacation or
we have it on 12th.
Yes.
You give an update as to what is the entitlement. It has been submitted by Mr. B. Gogoi, the learned additional advocate general Assam, that in pursuance to the meeting held on 20/11/2025, the petitioner was asked to submit certain documents which the petitioner have duly submitted. The PWD authorities are now verifying the same, and upon necessary verification, the same could be forwarded to the GAD department for onward payment. So taking into account the above, this is the matter on 12/12/2025. So on the same date, Mr. B. Gogoi, the learned additional advocate general, shall apprise this court as to the shall apprise this court as regards the verification so conducted in respect to the claim of the petitioner. Yes, what is this? Yes, Karbi Anglong has filed affidavit. What is your stand?
We have raised 3 points further. Whether without completing the work further,
Ah.
the petitioner approached this problem further.
Ah.
And second further, in the contract agreement, there is a clause of arbitration. And the third further, Karbiana autonomous completed the body complete on the 6 schedule without making the Karbiana autonomous complete with the requisition. These three considered. And in that case, my when there is a dispute further, from our high court further, in the maybe later method, Supreme Court has also passed in judgment method. 2021 KNS institutional.
Whether judgment is not there.
This from our hand. In paragraph 6, 7. Stated in paragraph 6, 7, my lord, that the petitioner has not completed the work, and no statement was made also in the petition that petitioner has completed the work, and no bill was submitted, my lord. We have the record, my lord. Petitioner is required to submit the bill, my lord, and the bill submit, my lord, which is prepared by the my lord authority, my lord. There is no signature of the contract.
Where the bill?
Well, petitioner has enacted also, my lord.
Where?
That is in page 22, my lord.
Some junior engineer PWD?
Page 21B, my lord. If you want to look into page 21B, the column signature of contractor is blank. 21B.
21.
Last column, my lord. Signature of contractor.
How much is the petitioner claiming?
In that case, my lord, petitioner claiming 2 crores 60 lakhs 38,500.
5 crores only admitted amount in connection with the work. Where is the admission?
There is no admission.
Yes, you may kindly allow watches to the documents which would speak of their admissions. You kindly have page section 5.
Page?
Page 28. Affidavit respect has been filed in denial of their own documents, only their submissions. Just as an afterthought, to raise a dispute with respect to the recoveries. This is their own document. Acknowledging the incomplete final bill system as the affidavit and the exact amount.
So it is just a forwarding letter.
It's a forwarding letter, it's a demand.
Incomplete final bill. The word is there, my lord. That means the petitioner has not completed the work. Was to, my lord, incomplete final bill against work. So it clears that the petitioner has not completed the work. I have, my lord, my lord, and the
So
agreement.
maybe incomplete, maybe a running account bill may also be there. So there is no quarrel with that. But the fact is, where is the admission?
This is acknowledging the fact that this much work was completed. Out
Where?
of the total.
Incomplete administrative approval. Show me the enclosures of this document.
The enclosure is the, are the incomplete bills for us. which
Where the administrative approval?
21 feet,
Where are photographs?
this is photographs are not.
What is this? How do you claim all these things here?
Not my submission is in the affidavit. For the first time, they have raised all these objections. No communication ever made, despite the fact that I have written several letters to them, which have been acknowledged by them as well. And my legal notice also, which was referred for further action. These objections never saw the light of day. No letter, no correspondence. The affidavit is not supported by any document.
Where is the agreement?
The contract is not with me, man, so I only have the work orders. The contract was not provided.
And where is the arbitration clause?
Because that they have come up with. That there is
No, you must have entered into on the basis of a tender.
on the basis of it.
Is the tender document not there? Does the tender document have an arbitration clause?
No, the tender document is not there. on the
Then-
board. I have the work orders which I have very technical.
No, not so. How can we direct this?
Madam, looking to the fact that the incomplete bills what they are referring to have been duly certified by the executive engineer.
Aha, whether it is, first of all, I don't have anything against the executive engineer. But with the executive engineer not filing an affidavit out here, I would not trust him. One. Secondly, executive engineers keeps on giving these liability statements, which is creating a havoc. And thirdly, tell me, what is the name of the executive engineer who have issued this document? Whether he was there, who thought they wrong?
Here's the signature of,
Huh?
here's the signature of the association.
Now, this person has filed the affidavit. You have filed the affidavit. What do you say on this? No. What is your statement in respect to this 24th April 2023 document?
That is my lord, an incomplete bill, my lord, without completion
Now, what
of
do
the
they
bill.
say? What does the, because this is the person concerned who has signed it.
Well,
What does he say on this?
my lord, that is the executive signing, but he has specifically stated that bills, that is the incomplete final bill he has submitted, my lord. Only the seeking the proposal, my lord, one, it does not mean that the petitioner is entitled to get the amount, my lord. And this is the not admission that the petitioner has completed the work. Seeking fund is the my lord different thing, my lord.
No,
So that
but,
petitioner
this
can
is,
be
no,
compelled to complete the work.
Mr. Sudhir, one thing very serious about this thing.
My lord, if it- my lord,
No, it is very serious.
My-
This thing needs to be corrected.
My lord,
This very executive engineer who is the deponent of your affidavit,
my lord. It is
he
same, my lord.
certifies. Now, why is he taking, either he has to say that this document is wrong, or he has to say something. I would have understood any other executive engineer coming and saying something else, but this is the same executive engineer. So therefore, why has he not categorically mentioned about this? What is the effect of this document?
My lord. Okay, that I have.
Let us have it affidavit,
My lord.
proper affidavit.
Okay, I have.
No,
included
Mr. Sudhir,
my lord.
this executive officer,
It is in our-
engineer,
my lord,
on 24th of April have forwarded this proposal.
my lord.
On the other hand, this very executive engineer files an affidavit in opposition.
Right.
Now, what is the stand as to what is the effect? What does it mean by this document?
This document means that the petitioner, my lord, did not complete the work, but he has, but the. bill
But
was
he is
prepared, my
entitled to
lord.
547.
Bill was prepared, my lord. So, my lord, executive seeks the, my lord, that whether the fund can be given, a fund can be, he seeks the proposal for, send the proposal for fund, and the completion of the work is the main basic things, my lord, in this particular.
Now, whether completion of work will consider.
My lord,
Have you terminated his work?
my lord, the period of work is, my lord, 12
12
months, my
months.
lord. He has not completed the 12 months, he has not submitted. any
If you have
application for
not,
it.
have you taken any steps against him?
My lord, the petitioner, my lord, he has the, my lord, within the period of 12 months in one work and one work is for 18 months, which is about 11 crores. He has not completed the work, both the works. my
So
lord.
what steps have you taken?
My lord, as he has not completed the works, he is pending in like that.
It cannot be. You are to take steps. You have not taken any steps. But the fact remains that he has forwarded this document. So I think this executive engineer should come up with a better affidavit explaining the contents of the annexure file.
May also consider two things. My retention money was also refunded by that 24 lakhs. Retention money was in the nature of the security deposit. Upon submission of these bills only, incomplete bills as they are talking about, they funded my retention money as 24 lakhs without any objection, without any problem. They never had any protest to begin with. Secondly, there was a COVID period which was running during the currency of this very project. And there were logistical difficulties which had left it, and they're not admitting to it. I can very much understand. But there were difficulties, and that's why incomplete bills were raised at the direction of the chief engineer. Though I've stated so, my statement is there in the petition itself. But the refund of retention money itself, is evident of the fact that they never had any objections.
Or in the otherwise, it is a case of abandoning.
Not abandoning money.
No, they are abandoning. Otherwise, why will they return you the security deposit?
But that's
Security deposit or earnest money is returned only after the culmination of the contract, isn't it?
my assumption.
So we should get a clarity from the executive engineer as regards annexure file.
I can find documents.
Okay, and what else are the other documents? You are asking for other money? Are you asking for any other
And
money?
secondly, whether it's in their affidavit, they have stated that I'm asking for the interest also, which is a patently false statement. I have not paid for the interest part. You can put the see my fare. I have clearly only demanded for the payment of the amount which is the balance and not the interest part.
Kindly come to page 70. Total interest charges on delayed payment. Why you are saying not?
That's my apologies for that. I'm abundantly.
I don't see the file
Because I'm not
before coming to the court. But one thing good is the moment somebody says and it automatically attracts my attention, that line, page. So therefore, we are going to dismiss your petition. But prior to that, let us get a clarification from that executive engineer in respect to annexure file. Because why I'm doing so is to put these executive engineers in certain leash. They have created a havoc in PHE, PWD, isn't it, Mr. PWD, PHE, all these places. These people are giving these liability certificates like anything. So, more than 10 years, 12 years, they are doing it. So therefore, let us ask him, because he is the very deponent. What does he say about the annexure file?
Annexure 5, my lord. That statement was
Not Mr.
regarding my
Mr.
lord,
Sitye,
my
not
lord,
your version. Let us hear his version. That is,
I have
that,
interacted with him, my lord. I have interacted with him, my lord. It is very difficult to get the original papers from them, my lord. What after yesterday, I got the, my lord, original papers, and in the open court, I have not submitted, my lord. But how the petitioners can get all these benefits, my lord?
that I know.
My lord, 11 crores they have not, my lord, they have not annexed any document there. They completed the work, they submitted the bill of 11 crores. And second is the work of the 6 crores, my lord. From that, they have already get the running account bill about the 3 crores. Now, my lord, that letter has been sent, my lord. And when I asked them that the bill was prepared, my lord, by the office, my lord. It appears from the records, my lord. It appears. There is no signature of the contractor. I have the original papers, my lord. Without signature of the contractor, it is processed, my lord. This was done. And if you lordship will look into the original contract, in every contract in the Assam PWD, there is a standard format. But in this particular case, my lord, something other is.
For clarification sake, I have never been my case that I completed the entire contract and then I
Record them until that. If he has not.
No,
completed,
but Mr. Council, can you listen? If there is a serious dispute as to your entitlement, can this court grant you, ask them, because this court cannot also pass an order, kindly pay him 5 crores. The only direction the court can give you is verify and then to pay. Now the problem arises in these direction of verification also, because they may not have documents to verify, and therefore to verify becomes very difficult, and resultantly our filing of contempt matters. It looks very innocuous. You kindly verify and make the payment. But you cannot certain period if you don't have those documents. So you are to get this 5 crores. So get it through the mode by which you have duly agreed. Why should this court entertain have this type of litigation?
My only respectful submission was that only at this belated stage they are coming up with all these objections. No correspondence, no letters ever were exchanged on their behalf. Nothing was sent to me ever reflecting the objection what they're.
No, you see, they are taking certain objections like Karbi Anglong has not been made a party. In fact, these are various aspects which you should have. But anyways, I'm not going into all those things. But don't you think that this is a case where disputed questions requires to be, because there is no admission on their part that it is, and this document cannot be treated as an admission. And at the end of the day, this court can only pass an order of verify. The problem is verifying is also a very difficult thing. You have a contract order submitted in incomplete bill of A, and the same was duly certified by the PWA. Respondent made a partial payment of 3 crores against the incomplete bill and remaining so and so. So when did you get the remaining amount back?
3 crores.
Where is the amount, the retention amount was returned to you? Where is it?
That was on.
Huh?
That statement was from there, just now, that statement was.
Yes, yes, where is it?
Security money was refunded.
I have the document and I can file it from the court.
Oh, Mr. You are making this type of submissions just without knowing it. Because they kindly come to your legal notice. Not a single word in that regard have been mentioned. Then,
That I really concede.
then
Only after the last day when the matter had come up, we wait for the inquiry. And it got revealed that my retention money was also refunded by them. I can put the papers for it.
when did you file that affidavit? 28. We have to can finish it off next week. Give him 7 days time. Tomorrow, no, otherwise he will say that in 7 days time has not been granted as per the High Court rules to file a reply. Then we dismiss it better off. Okay.
I would say that maybe directed to when I know the relevant documents regarding the project news, because I'm in a difficulty from that.
Are you going to file a reply to this document?
I'm sure.
Chalo, you file your reply within 7 days. We will have this matter on 12th and finish it off. It is seen that an affidavit in opposition has been filed on behalf of the respondent, Karbi Anglong Autonomous Council, through the Executive Engineer PWD Kohora Road Division. Full stop. The Learning Council, appearing on behalf of the petitioner, submits that a week's time may be granted for filing a reply. List the matter on 12th of December 2025. The reply be filed on or before 10th of December 2025. Okay. Oh, is it?
By saying that the matter is under consideration.
Where? Where is the affidavit? Police. Where's the admission?
Next page.
Where?
One more. Out of the same quotation mark, the adoption is submitted disclosure of several expectations.
Now, what is your decision? Revenue?
In our revenue is there is one of the, we are going to verify and submit the.
Okay, verify and pay.
Well, it is similar quotation will get submitted, so out of the same quotation,
What will be?
another expectation.
Oh, yes. They are getting all this non-payment of dues matters, so many. This is also cattle feed.
Yes. Para 3 I have started.
All these amounts, why is it appears, this is 52 lakhs.
Yes, 52 lakhs, 46,000, no, yes, 46,780.
So earlier also you filed with petition. What is the number? लिखी हुआ number.
So, PPC number 7900/2017.
7900
00/2017.
order dated
The order dated 21/1/2021.
passed in a bunch of writ petition or a single order?
Single order. Just page 79.
Thereby directing the respondent authorities to examine the claim of the petitioner and pass appropriate orders indicating the amount payable to the petitioner within a period of 4 months. That was the direction. Then you submitted the order dated 21/01/2021. Submitted. So and so. And what is the inquiry report? Same.
Actually, the inquiry report that is submitted, that was admitted, and I can.
What is the inquiry report now?
It's a 10 lot, page
Page
80.
88. Same dated 16 line.
58.
This is 9/8.
Yes.
Inquiry report.
This is last inquiry.
9/8, na?
Yes.
Findings of the divisional forest officer or what?
No.
What?
This is for relief materials. So that's what.
By various authorities.
Yes, sir, Madam, sir. Yes, sir, Madam, sir.
Now this matter went to the vigilance.
No, madam. Vigilance is also complete. The report.
after the vigilance and the lower Assam commissioners report, this is the final report which was submitted by the High Court Commission, distributed by the Government of Assam.
Paragraph 5.2 indicative. Mr. J. Hendrick, the learned counsel appearing on behalf of the Revenue Department, submitted that an affidavit in opposition has been filed by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, wherein it has been mentioned that the details have been received from the District Commissioner, South Salmara, wherein it has been shown that an amount of rupees 52,46,783 is payable to the petitioner. This aspect is being verified with the records as to whether the petitioner is entitled to the said amount. Also, paragraph 522 Gusai, it is here to notice 6 of the 7 of the Sida Tira. So then the same directions. Economic correction. Give your dates, number. Yes, what is this? What is this contractual bills are coming on? What do they say? What is your claim?
29,43,000. And I have talked with my client, they are not going to the dispute, they are agreeable to the amount.
How much? 26 lakhs.
74,800. And similar order was also filed by this, for that your lordship will find page 120.
Paragraph 8.2. Paragraph 8. Put query. Huh? And then what is this similar orders?
Page 120.
What is this order? Will be my order. Take an affidavit file affidavit file, paragraph 8L 10. Put query, taking into account that this amount is duly admitted, so pay within 6 months. And a certified copy to be given to whom?
Respondent number 5.
Who is he?
Director.
But you are
Non-payment. Did Mr. B. Pukon, appearing on behalf of the petitioner, submits that in the meantime, the petitioner have already received the dues for which the instant petition has been filed. Ms. So-and-so appears on behalf of the health department. Anything is there? No. Okay. Taking into account the above, nothing further survives in the instant petition. The petition accordingly stands closed.
22 and 23.
The interim order.
Huh?
The other citizens is having the benefit of the interim order, this of the order.
Interim order?
I am not on that. They have, we have filed a counter and they have also replied now.
What is the matter about? To submit the petition was empaneled as so and so and an offer in the demand issue notice, their interim order will be considered. What is the interim order? What is the order? What order is this? 960,000?
I think lordship will find at page 357.
Page
357.
57. Construction of a 6-lane standalone flyover at Bongaigaon, Sophaiguri Cement. Oh, that one. Engineering.
Yes.
Ah, now I get it. Yes, now what do you have to say?
The pleadings are complete. It is even for finance. It is the month of January. And we not equal. Yes, we did also. 2G. Not equal. 2G. We did. Other party has also.
Water same, na?
Different categories.
You also got an interim, na?
Yes.
I gave you later on.
Yes, I do.
Taking into account that the one is for your case was for consultant.
Proof consultant.
Proof. And you are
Safety concern. Safety concern. Which are audit, pattern running for audit.
taking into account that the pleadings are complete and an urgency is being expressed for early disposal. Lest the matter when
20th of January.
okay, 201/2026, 2 p.m. for final disposal. Interim orders passed earlier shall continue to the next day.
Hello.
What is that? What direction? You want your name to be there? Your submission is over. What was the matter about? I forgot.
Regarding a scheme which was sponsored by the Bank of India. We were the independent authorities. Now they are studying that they have stopped the scheme. And on their SUS, we have work orders. Now they are saying that you can pay on your own source. We have stopped the detracted. We are not denying, we are not denying. We will not pay.
You have to take it up from them. Item number 20. Get hold of your other counsel. Where is he? You cannot make a submission of all the after the order has been passed. Get hold of him. Not two. Get hold of him. Otherwise, by 2 the order will be signed. I don't recognize that you have made a submission also. As if you are a blurred picture now before me, unless you get the other side counsel. Yes. I am not going to hear anything. Get hold of your other side counsel. Then we'll. Yes, Mr. Samali.
Hello, the direction was given to the PTC for filing affidavit.
What is the matter about? Lease rent has not been paid. Oh, Kendriya Vidyalaya. What? Why? Why haven't you filed your affidavit? Does the senior have to come to say that, oh, I want to file an affidavit? It's just the state of affairs of the councils. Why haven't you filed the affidavit? Or you don't want to file the affidavit? Then why haven't you filed the affidavit? Matter has been filed. The whole matter. You see? Notice was issued as far back as on 6/8/2025. We are in the month of December. Very late. You are for Kendriya Vidyalaya? Madam, you are for Kendriya. And Ms. Yudas, I sought for certain instructions. Huh? other than the, in the meantime, respondents, other than the, are given the liberty to clean up the court. 326 F5.
Yes.
And I asked the District Commissioner Udalguri is further directed to provide necessary instructions to Ms. Yudas in respect
I
to.
have received the instruction as well as I have filed the affidavit also.
When did you file?
On the 17th of 28. On Saturday, she has filed.
Okay, it has been submitted by Ms. Yudas that the affidavit has been filed on behalf of the District Commissioner Udalguri on 28/11/2025. So, however, the same being not on record, this the matter again on any urgency, no urgency, on 21st of January 2026. Full stop. A final opportunity is given to the BTC to bring on record the stand on or before 9th of January 2025-26. Failure to do so, this court shall proceed on the basis of the materials on record. What is the matter about?
Matter is regarding non-payment of- She can dispose it proper. I'm not problem. Thing is that the funds should be released by the government of India.
Why should I say?
As
Or the
per
government of
scheme,
India.
The scheme says so, madam. At least it is scheme, madam. That says 101, madam. 101.
You have filed the affidavit.
Yes, sir, I have forgotten.
As the government,
We are not from India.
government of
We are
India,
saying that payment.
huh?
101, madam.
What is that?
But this is a mail, madam, which is from the government of India. Here, they say that they stop the scheme.
But you have duly admitted.
Yes, we have written, madam, as per the instruction, madam, we are the implementing officer, agent, madam. We have funded it.
Okay, so we can have to get hold of that film. Wallet. Where's the union?
Renewable law, is the next, madam. 102.
Yes, Mr. K. Gogoi was appearing for the union. Who was you appearing for the union? Who appears for the union? Okay, we'll take it up again at 2. See what. Earlier, this is the second round, na? And get hold of the union. If you don't get hold of your union, again you're responsible. If he doesn't come, then again the order will remain. Then again, no, I'm not concerned. I'm not here going to hear again. You have to get again the union. No, I won't say anything. Let's hear the union. Why should I put anybody in it?
Pending item 20.
Let's see the scheme. Are you appearing for the Director, Employment and Craftsmen?
I am looking for account number 2456.
Okay. Now, the order which was passed by Justice Prasanto Dekar directed that you verify, and if it is found, to make the payment. Have you filed a review against this order?
No, madam.
Then-
Yes, my lord.
Then it is amounts to violation.
In that case, madam, both the respondents were directed.
No,
We wrote several letters. to the
I'm not
government.
concerned with that. Kindly come to page 72. (72) of the resolution.
My lord.
Upon consideration of the submissions. Read it.
Yes, I know. Respondent number 5 to verify the claim. Yes, ma'am. We have verified it, madam. We have found that.
Mr. Das, kindly read the entire thing.
Upon consideration of the submission before the the amount paid to the there is special amount or any other amount.
So you verified it and you found that 29,43,900 is payable. Now, why haven't you paid the money?
After we found it, what's the number? Our
No. I'm not going to look into other things. The direction is to make the payment by respond number 5. Why haven't you paid?
They have closed the scheme.
I'm not concerned. You should have therefore sought for a review of this order. Without seeking a review of this order or anything to that effect, you cannot.
After this, madam, order will pass in case number 120. Fill and have place, madam.
Provide your head of account. We'll attach it. We are not concerned how you get it. There is a direction to pay specifically upon respond number 5. There is no mention that it is to be paid by the union. We have not sought for a review.
But thereafter, madam, honorable court has given order. This order is at place 120, madam. Once it comes to the last page of the order, at place 128. At there are 24.
No, we are not concerned. That is a different party. No, it is a-
Same thing, madam. Same content.
Absolutely no. The question is, it is a different party. We are not concerned. Here it is a dispute between the petitioner who is Zenith with you. You said that here is a scheme. The petitioner imparted education. You have to pay.
We'll pay, madam. We are not denying that. We are not
You
denying
pay.
that.
How you get the money, that is your lookout. I'm not concerned with that. We are not concerned with those. How you get the money is immaterial. There is a direction to pay to you.
Sir, kindly come to this conclusion.
I'm not going to look into other things. That is another case.
Ma'am,
123 is another case.
Sir, this honorable court has observed that
let it be. That is another matter. How can I reopen another matter? Because of he coming before this court for the second time, because of the fact that you have not made the payment, he has to come in before this court again. Then pay. I'm not concerned. You should have therefore sought for review of this order. Without seeking a review of this order, can you say so? That we can only pay if the government of India allocates the fund. Where is the scheme? Where is the scheme? Why are you asking him? You don't know where is the scheme. You are saying that the government of India is, Mr. Das, you are saying that the government of India is to pay. Where is the scheme? Why haven't you brought it on record? You are filing this affidavit after a long time. Huh? I gave it to you on 12/11. It's something the affidavit has been filed. Then why haven't you brought the scheme? Nothing is there. No, we direct the. We direct. I think. Yes, Mr. C.K.S. Bulu. You were earlier appearing in this matter, no? Or no? Who was appearing in this matter earlier? No, somebody was telling me that you have made all the payments. Yes.
The state of Assam has to submit the whatever funds are required within a particular period of time, and that was last year, 6 months. Whatever use of all, including the petitioner of all, was they have to submit all the things. And in many cases, what has happened is they have not done that. So once that window was closed, there's no further fund from the central government. Government was given, state government was given an option. This is the time limit. You submit all the dues. Now, within the time frame if they not, then no further fund will come.
Where is it? I could see one document. Kindly come to 102. As you are aware, the skill development initiative was introduced by Director of the erstwhile Directorate under Ministry of Science. For the 12th plan up to Iman, under the scheme, the central government released the funds to the state to meet the expenses towards reimbursement of the training costs. Implementation guidelines also till Iman.
103, the last one.
At the time, the Ministry of Science launched the Pradhan Poshan Area for the short-term training across the country. Some states are still having unutilized funds under the retreating the And the petitioner submitted its first claim when? When did you submit the claim? They were submitted. Page 35 onwards. We are concerned with which period?
2013 to 16 losses, and in between only they had losses 14 lakh 63,000. Total amount was 44 lakhs.
You have received 11 crores,
Yes, sir. And we have paid for that.
and of which 8 crores you have used, and remaining remains unutilized.
Now we need for 10 crores. Now we need 10 crores. That people have been given to the government of India.
You gave much later.
Those bills were under official. Those bills we have not paid. They were under official.
So did you take it up? That you have raised certain objections. You have raised certain objections. Did you have any objection against the petitioner's bills?
Yes, madam. He was paying an amount of rupees 29 lakhs, madam. But his actual bill is 26 lakhs. And he has after the interest bill, madam. But Lordship, I will come to this. And he said, can I submit the test fee to this amount?
When did you make the verification? After the court's order? Prior to that, what were
Before that,
you?
also we have made the
What was done prior to that?
But prior to that, as soon as we received the farm,
Now, when did you receive when did you receive his bill?
Yes, point of time they have submitted. Immediately after. That I have stated in paragraph 3.
If you wake up only after court's order,
Not actually. We are dealing with it. Here also amount, those amount which was not under objection, that we have to him. This amount was under objection, and we have to submit a case.
Mr. Das, if you are to claim, you are claiming 100 rupees, and you say that, okay, somebody, the union has paid you 50 rupees, are you satisfied with it? Then,
If the payment is there, then the government of India will release the fund and we will make the payment.
But initially they released the fund. They have
No,
released the amount.
Government of India made all the details and also closed, giving you a window of 6 months.
Yes, madam. Madam,
Within these 6 months, whether his bills were submitted prior to that.
no, madam. He submitted only one fund, and those were under objection. And those-
When did they submit the bill?
That I have to take.
No, what is this? This is your basic case.
I have stated in paragraph 8 and they have
Madam,
not denied.
listen, madam. Madam, that case 101. The government of India had given us a mail that on 2016, they are stopping. They have stopped it, madam. Now, after that, the document case.
So where is the petitioner's bill? Where is your bill?
James Joseph Alexa 3 that starts from page 35 of the
Page?
35.
These are 2013.
Yes.
Then
Then was the page 38 also 2013.
all these are 2013.
Yes.
Then you don't make the verification on time. That is the reason why.
We have been, in time, madam.
But when did you do it? When did you verify?
After he submitted, but we, this is the, madam, this is not the only case, madam. You are very, very special,
I'm
madam.
not concerned with others, Mr. Swata. I'm only asking about the petition. Petitioner's bill was submitted in the year 2013 when the scheme was fully operational. The scheme closed on the year 2016, giving you another 6 months' time.
No, madam. 16, they have informed us to stop.
Now, giving you 6 months.
No, madam. No.
It's-
What people kindly see the mail, which the media has provided to us at 101,
Yes, 102.
101, for that. This mail was received by us on 2016. And the from madam, I didn't say. June 9, 2016, which is this mail, to stop. And they have informed us on 2024, madam, they will not release the amount.
No, on 27th of February 2024.
Yes, madam.
This is the direction.
Yeah, this is 24, madam.
Ah.
And this mail was given to us.
What is this?
After 16, my lord.
It is observed that some states are still having unutilized funds on the SDI. Reiterated that the date of the official closure of the SDI scheme is 31. Hence, all state governments are directed to provide the utilization certificate. Now, in the order passed by Justice Goswami, there is a categorical mention that you have received 11 crores
Yes, madam.
and 8 crores were utilized. What happened to the remaining 3 crores?
Raise was for return paper by the Government of India.
When did you return?
They have taken back on, August 2020.
They have not taken back. You have to return.
They have taken back.
How come they take back?
But they have, I did a visit, madam. It's only if you have seen, madam.
Mr. Counsel, kindly read 103.
102.
103.
My lordship, sir,
You read 103.
that's from the-
Yes, read it.
they have to observe by some, stress and which is actually having under the situation that the name of the closure of the address is 31/7/2017. It's a wrong statement from this by the madam. Your lordship, kindly see that page 101, that this mail was given to us on 2016, 9 June, 101.
No. 101 is different. 101 is, please refer to the releasing of funds of air from 2016. We are not. During this financial year, no funds have been allocated to the SDI.
Therefore, no plan has been released to the state of Assam.
Understood, but the petitioner's bills are of the year 2013. Then all these are 2013.
13 to 17.
No, 17 you can't get it. 17, how can you get it? Not under this scheme.
Was submitted on 17. That are relating to also 13 and 14. All the bills which I have posed here. 35
Where?
page 35 onwards. also. The relating to some 13 and 14. That page 38 also have document 5. The training starts on 27 to 2013. Page 38 also.
No, I'm not there. Where is the bill of 2017?
So 17 of the 17 submitted. Commission from 2013 to 17, they have at various points of time, they have submitted these.
Where is that bills of 2017?
17 bills is not there.
Then
So,
that means you have not enclosed all the bills.
No, submission date. is
You have not
17.
enclosed those bills.
No, bills were of 13 and 14. It was submitted from 2013 to 17.
Now, how can you submit in of the work done in the year 2013, 14 in 2017? Why you are asking a petitioner a fresh bill? No, you found out after verification that the petitioner is entitled to some 26 lakhs. Then why is it required for the petitioner to resubmit again another bill? No instruction business. You have already taken a lot of time. We are get the director better off. Then let him get all the files and let us come. This is not done. I'll ask you, you ask for determination here. Kindly come to page 91. Thereafter, a bill verification committee has been constituted by the Directorate for verification of the pending so-and-so claim bills of BDA and assessing and the report of so-and-so has issued direction for clearing these claims chronologically to so-and-so dated so-and-so. And as there are many VTP and so-and-so. So as on 22/2018, you still had funds.
We have done. Those funds we have given my own.
As on 22, when did you give? When did you return the funds?
But if your lordship see about
Where is your statement that you have returned those funds? What 101? When did you return those funds?
On August 2021.
Where is it? Then you better produce your head of account. We need to attach it. I give you 15 days time. We'll have it on 15. Produce your head of account. We attach it. Let them not get anything. No. Nothing. Chalo. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.P. Das appears on behalf of the respondent numbers.
2, 4, 7, 6.
2, 4, 5, and 6. Mr. Arkadev Chaudhary appears on behalf of the Union of India. This is the second round of litigation whereby the petitioner had to again approach this court in spite of there being a categorical direction passed by this court on 2/9/2021 in WPC number 5611/2020 that the petitioner, that the respondent number 5, who is the director of employment and craftsman training, should verify as to whether the petitioner is entitled to the amount of rupees 29,43,930, and if so, then to make such payment as to what the petitioner is entitled to. The relevant paragraph of the said order dated 2/9/2021 in WPC number 5611/2020 is reproduced herein under paragraph 70, page 72, 73. The petitioner thereupon requested the respondent authorities to abide by such directions. However, the respondent authorities did not take any such steps. And as the petitioner did not receive any amount, the petitioner had to again approach this court by filing the present petition. It is seen that pursuant to issuance of notice by this court on 2/5/2025, the respondents numbers 2, 4, 5, and 6 have filed an affidavit to the Joint Director, in charge craftsman training in the Office of the Directorate of Employment and Craftsmen Training, Assam. In the said affidavit, it has been categorically admitted that the petitioner is entitled to an amount of rupees 26,74,815. The said amount have been arrived at after carrying out necessary verification. It is also mentioned in the said affidavit that on account of the Government of India withdrawing the scheme, the respondent authorities are not in a position to make the payment. On the other hand, the materials on record suggest otherwise. In as much as at paragraph number 6, there is a categorical statement that payments were made by placing the persons who are entitled to the amount in a chronological list. Considering the fact that the directions passed by this court dated 2/9/2029 have not been passed in WPC number 5611/2020, have not been complied with in spite of arriving at the conclusion that the petitioner is entitled to the amount of rupees 26 lakhs so and so, this court fixes the matter again on 15th of December 2025. On the same date, the respondent number 5 herein shall provide the head of account of the Employment and Craftsmen Training of the Directorate of Employment and Craftsman Training. So that appropriate directions can be passed. Attach. 15th. 15th is a good day. Don't appear. And if you don't appear, ask the director to appear with the head of the account.
Percentage item 1 for Muslim.
Yes, what is this?
Happening to our
Yours was rejected for what reason? UDN. Yes, I forgot. That your certificate, the bank statement or whatever may be, or the certificate of the chartered accountant did not have the UDN number. It is not in terms with Annexure 5, isn't it? Okay. That day I didn't dismiss it on merits. Today let me dismiss it on merits.
No, I have a case file. I have a case file because that notice inviting vendor at page number 50 get the requirement of 3 points at page 50.
Yes.
Point number 1.
You say that if there is a submission of the last 3 years audited balance sheet, then there is no requirement of the certificate.
Certified audited balance sheet is 1 point by the already certificate from the certificate accountant. Third point is the
You are on the OR.
I am in the OR. I have submitted the certified.
You say that the OR certificate is not required. The chartered accountant certificate is not required, taking into account that this is it.
Yes, but
You have already submitted.
yes, but page 59 there's point 4 and
4N says that it has to be in terms with
Annexure 5.
5.
But this is only the supplementary. It is for the additional point. That is why we have got it. Because other points are still there. Certified audited balance sheet is still there. It only says that certified of certificate of chartered accountant about average annual turnover of so and so of the bidder during the first 3 finance years as per Annexure 5. That's only it says. So my submission is that kind of certificate certified audited balance sheet but is still there and they have not considered. When they detected my submission, it is at by the pilot test 78. I'm reading at the pilot my submission. We are submitting the latest CS certificate of annual turnover of last 3 years, consecutive year, signed and sealed by the chartered accountant CA with a daily PIN number for your time, review and approval. This is on 30 days. On 1st November, they have rejected it, which is around the bidder failed to participate with their financial certificate. There is no requirement under the NITD, ITD or additional terms and conditions. Like it mentioned mandatory audited financial certificate. Audited balance sheet has been submitted. They have not considered and they developed this one type of details. In the previous case, when they ignored my rejected my CS certificate, they said that usually PPI number is mentioned. Whereby by mistake I have not mentioned. Now they have mentioned that failed to submit mandatory audited financial certificate. Since I have submitted this is my balance. I am reading subsequent divider. By the bid submission deadline, 24 days.
Mr. Counsel, your basic case is on OR,
Yeah.
nothing else. So therefore, your case is when the main NIT was issued, it said that either you submit this or the audited accounts. You submitted both. There was a problem with the with the audited AR because the UDIN number was not given. But your case is that in view of the stipulation contained in the main tender, the subsequently or inserting that particular cannot override the main condition in the tender. That's your case.
It is only the supplement, my lord, supplement to this particular sum.
Understood. Therefore, you are saying that the other condition like instruction to bidders are just supplementary, but it cannot override the main condition put in the GEM portal.
Yes, my lord, so far as this happens, because in the same portal, they clearly give three options. So, my lord, only regarding.
What are the three options?
Certificate with balance sheet, my lord, point number one. Certificate by the CA, second point. Another is certificate by the cost accountant. Even if somebody submits the certificate by cost accountant, then this annexure 5 is not applicable. Only pertaining to CA certificate, they mentioned that please provide the certificate.
So therefore you say that CS certificate, if you don't give also, then also if you have submitted the audited balance sheet for the last 3 years, you cannot be rejected. That is your case.
Yes, right.
I understand that.
There is another point, my lord.
Yes.
There is a page 41, there is a work plan presentation, which is mentioned here. And there is 5 marks has been provided for that activity. But it is supposed to held on 13/10/2025. Annual time is already also provided. But there is no such presentation that has happened. But respondent number 6 is granted marks. 4.5 marks out of total 5 marks. But in our case, there is no such presentation. There are altogether 36 bidders participating in the bidding. Only 2 qualified for the technical bid. And both are given marks. One is given 2.5 marks, another is given 4.5 marks.
Let us not go into the second chapter. The second chapter will come only after you qualify the first. Isn't it? First you have to qualify. Qualification is now, can we this code treat it as or it is the mandate that the instruction to the bidders will override what is the condition in the GEM. That's it. First, that is the question.
Page 40 condition is concerned. Minimum average annual financial turnover of the bidder during the last 3 years ending on 31st of March of the previous financial year should be as indicated above in the document. Documentary evidence in the form of certified audited balance sheet of the revenue year or a certificate from the chartered accountant. There's cost accountant indicating the turnover details for the revenue year shall be uploaded in the document.
His case is when you are saying or, then it is not the requirement. Although instruction of bidders categorically saying for
That's
N.
why I'm saying what is required. This is a standard particular condition 1, 2, 3, and 4. They are in every GEM bid. It is always there. But these instructions that we have there.
So there must be something mentioned somewhere that the instruction to the bidders would supersede what is mentioned in the GFR, a GEM portal. Where is that?
Page 48.
48.
Yes. This page 48, last second paragraph. This bid is governed by the terms and conditions of CBC. Terms and conditions stipulated in the bid, and service level agreement specified to the service as provided in the marketplace. However, in case if any condition specified in the terms and conditions contradicted by the conditions stipulated in the service level agreement, then it will override the conditions in the general conditions. So the general terms and conditions will be one of this. Because that's why even the format has been given. Lordship will see page 49, clause 4. Technical bid, what are the documents that the technical bid will consist? This will consist of supporting documents as proof of meeting all eligible criteria. Here, that balance part is not there. Had it been a necessary condition, it would have been there. We would have sought for it. These are the documents which are to be submitted. If you can show my lord from my lord 4A to 4T, my lord, the balance sheet is there, my lord, then my lord, you may have a case. And in fact, my lord, the format has been given. The page 66, now you will see my lord. Certificate regarding annual turnover of period during the last 3 financial years.
Where?
Page 66, Annex 5.
But that is what,
In fact, my lord, down below the UTI number, my lord, that's required, my lord, it is indicated here. It is 50 number.
The balance sheet is the more detailed document, where it is not specifically mentioned. Only, otherwise it will clearly clarify that these two documents are not applicable. If old and it then says that regarding the certificate of certain accountant, it must be under Annex 5. It says only that much. Otherwise, it may be clarified that these two documents are not applicable.
so now you say that the last 3 years audited balance sheet is not required.
Well, this is by course number 4. Course number 4, yes,
Where is it?
page 49. Technical review. What the technical review consists? It says the technical review. These will consist of the supporting documents as proof of meetings, the eligibility criteria. Now, and says about the etc. Because balance sheet is not there.
So are you saying therefore, I think you should file an affidavit. Because this is a thing which requires an affidavit. We should pass a stay order. What do you say?
My lord, the term of the contract was still yesterday. The term tenure of contract was still yesterday.
You are in contract?
No, he was in contract. My lord. Now, my lord, it has been allotted to the fresh one. New one.
Page number 55.
You had a contract?
Yes, sir. It is
Earlier.
okay.
Oh, if it is state, now if it is state, we do one thing, we state that work order, but we allow the private respondent to carry it.
No, work order has been issued. My lord. Lord Summary pays it.
I know that is the reason why. I was waiting that, I thought of dismissing his petition on merits when you come. Earlier, Mr. D.P. Bora appeared.
But yes. So, my lord, this ground he has taken today. My lord.
Which one?
This ground that my lord, in lieu of my lord, that annual turnover.
No, he took it on that day also. I wanted to dismiss it on that day. Then I felt that, okay, why should I dismiss it on merits in the hands of Mr. D.P. Bora? Let me dismiss it in the hands of Mr. B. Gugoi. Anyways, but one thing out there, let us issue a notice. I won't stay it, but you file an affidavit because this is very essential. Because tomorrow you cannot change your stand. No heavens is going to fall.
But till now, there is no communication to hand to the service.
My information from the superintendent.
Anyways, your contract has come to an end. So there is no equity which will flow upon them, merely because of the fact that I have not granted stay order. Let them put it on affidavit, this aspect, which may aid later on, because this is a very important thing, which may help in other matters. Because I am here always keep on doing it, because I see contradictory stand every day. From the PWD, there is a contradictory stand from health also. Let us now take up one stand as to whether that will override this. Let them come up with categorically. Because why they cannot say, let us see this. Kindly see page 47. These are additional terms and conditions have been incorporated by the buyer after approval of the competent authority, whereby buyer organization is solely responsible for the impact of these clauses on the bidding document, its outcome and consequences thereof, including any eccentricity restriction arising out of the bidding due to so and so, and due to modification of technical and so and so are to be incorporated by the buyer regarding following the bid, and resultant contracts shall be treated as null and void, and such bids may be cancelled by the JAM at any stage. Definition of so and so seeking EMD submission of the year including so and so. Now it is seeking flotation of area, mandating foreign so-and-so, seeking experience from so-and-so, creating bid for area. So these are the things which are here. In any category based bid, adding additional terms through the buyer added additional scope of work, additional so-and-so. If the buyer needs more items along with so-and-so must be added to the bunching so-and-so and etc. And the same must be done through etc or scope. Further, if any seller has any objection, grievance against these additional clauses or otherwise on any aspect of this bid, they can raise their representation against the same by using the representation window provided in the bid. Details field in so-and-so after logging as a seller within 4 days of bid. Publication on the GEM here. Now, the GEM has a particular, they have a particular terms and conditions. Not here, they already have. So there it is categorically mentioned how it is. Anyways, let us wait for a day. Issue notice, making it returnable on, when do you want it? 17th December. Okay. Issue notice making it returnable on 17th December 2025. Mr. BOA accepts notice on behalf of the respondent numbers 1, 2, 3, 4, 5. Full stop. Extra copies of the petition be furnished up to him by tomorrow. As regards the respondent number 6, the petitioner is directed to take steps by way of speed post by tomorrow. Additionally, the petitioner is also directed to take steps by Dusty upon the respondent number 6 routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the service upon the respondent number 6 by way of Dusty is done on or before 8th of December 2025. First of all, the case of the petitioner here, the petitioner herein is aggrieved by the rejection of its technical bid on the ground that the petitioner did not submit the mandatory audited financial certificate on or before the deadline, bid deadline, that is 24/10/2025. Mr. Borua, what's your name? Me, Mr. B. Borua, learned counsel appearing on behalf of the petitioner submits that in terms with the notice inviting tender dated 3/10/2025, clause, it is stipulated in clause number 1 that the minimum average annual financial turnover of the bidder during the last 3 years ending on 31st of March of the previous financial year should be as indicated in the bid document. He further submitted that the documentary evidence in that regard are threefold. First is threefold. One, first is the certified audited balance sheets of the relevant periods. Second, a certificate from the charter accountant. Third, a certificate of the cost accountant. The learned counsel submitted that these certificates from the charter accountant or from the cost accountant has to indicate the turnover details for the relevant period. He further submitted that either or any of the 3 documents would have sufficed. The learned counsel further submitted that the additional terms and conditions which have been incorporated by the respondent authorities, more particularly clause 4N, is contrary to the bid document submitted by the issued by the GEM portal, and therefore, on the ground of non-compliance with clause 4N, the bid of the petitioner could not have been technically held to be non-responsive. The learned counsel further submitted that by technically rejecting the bid of the petitioner, the respondent authorities have already issued the work order to the respondent number 6. He further submitted that in certain interim directions are required to be passed, else third-party rights and equitable interest would accrue upon the respondent number 6. This court, having heard the learned counsels appearing on behalf of the parties on the aspect, per contra, Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent authorities, submitted that the additional terms and conditions, that the terms and conditions which have been incorporated by the respondent authorities would override the terms and conditions in the GEM portal, and more particularly clause 1. He therefore submitted that it was mandatory on the part of the bidder to submit the certificate of the charter accounted about average annual turnover of the bidder during the last 3 financial years. In addition to that, Mr. B. Gogoi, the learned additional advocate general, further submitted that the said certificate has to be in terms with Annexure Roman 5. A perusal of Annexure Roman 5 would show that the said certificate has to contain the UDINN, UDIN number of the UDIN of the charter accountant, and in absence of the UDIN number, the said certificate cannot be taken into account. The learned additional advocate general further referred to the certificate which was submitted by the petitioner. Where is that original one? Submitted by the petitioner, and which is enclosed as Annexure 5 to the writ petition, wherein it is apparent that there is no UDIN number. He therefore submitted that this is not a fit case for issuance of, this is not a fit case for entertaining the writ petition, not to speak of passing any interim directions.
It is the matter of chartered accountant turnover. This is page 69, clause 70, column 70. Last.
Okay, ladies. Page 69 of the other line. The Mr. B. Gogoi, the learned additional advocate general, also referred to the checklist of the documents to be submitted by the tender, and more particularly at serial number 17. In addition to that, the learned additional advocate general has also submitted that the petitioner knew very well that the said certificate was essential, and therefore submitted a certificate which, however, was not in terms with Annexure 5. The learned additional advocate general submitted that at this stage, after having been rejected, the petitioner have taken up a plea which is nothing but an afterthought. It is therefore the submission of the learned additional advocate general that this is not a fit case to be entertained in the exercise of the powers under Article 2 to 6 of the Constitution, not to speak of issuance of any interim directions. This court have heard the learned counsels appearing on behalf of the parties on as to whether any interim directions are required to be passed, taking into account that the respondent number 6 have already been issued the work order, and the materials on record otherwise, and yeah, it is the opinion of this court, have already been issued, it is the opinion of this court that the respondent number 6 ought to be given an opportunity of placing his case, its case. Apart from that, it is also the opinion of this court that the stand of the respondent authorities are required to be taken. Considering the above, this court therefore considering the above, the respondents are directed to bring on record the stand by filing the affidavits on or before 15th of December 2025. On the next day, this court shall make an attempt for disposing of the petition. If the writ petition is not disposed, cannot be disposed, may consider granting of interim directions subject to the stand after duly taking into after considering the stand of the respondent authorities. It is further observed that non-granting of of any interim directions today shall not create any equitable right over upon the respondent authorities, including the respondent number 6.
For this one, the record and the.
In fact, I would have dismissed it today itself. But it is his second petition. It doesn't look nice. No? First he has come, first day finished. Second day he has come. Okay. Second day, Mr. Guru, I'm telling you, next day I'm dismissing it. I'm dismissing it. The only thing is today I didn't want to. This is your second petition. It won't look nice.
Release item 25 for admission.
Fukon, where is he? However, the same has not been done and yes, what is this? What is your stand? He has not taken steps. Okay, none appears on behalf of the petitioner on call. Ms. Yudas, the learned additional senior government advocate, submits that to her information, no steps have been taken. Taking into account the above, lists this matter again on 2nd of March 2026. In the meantime, the petitioner is directed to take fresh steps on the respondents.
36.
Edeka, yes, what is this? 9 lakhs. Affidavit filed. Payment. The verification concerned within the petition had in fact claimed 88,000 excess so and so. Actual entitlement is 8 lakhs 81,000. Dispose of paragraph 6 to Putkuri, 6 and 7 Putkuri police notice. Disposed 6 months. Yes, Mr. D. Chakravarti, what is your case? Huh? Have they considered your representation? What is it? What do you want? Oh, that one. Establish that prior to an inspection being carried out that there being an unauthorized use of show cause notice was issued upon the theft. It is also relevant that the pursuant to the inspection being carried out final very bad case. So, don't come up with that type of excuse. As who is your senior? Tell him that I took up the matter when it came up before me. When he himself appeared, he didn't raise that issue then. Now, why is he raising this type of issues? He must have instructed him. Very sad state of affairs. This type of argument, you don't make it before me. So now, should I recall the order of 8/9/2025? Then, why no affidavit has been filed? Oh, it means here, we call the managing director. Wait, who is he? Let's see, no instructions. We have the chief general manager present. it is seen that no instructions have been provided to the, you have asked for, no?
Yes, we are communicating.
Okay. Mr. So-and-so, who appears on behalf of the respondent authorities, submitted that that the instructions were sought for from the respondent authorities, but they have not replied. It appears therefore that the respondent authorities do not wish to take the benefit of the standing councils. Considering the above, who is the person who should be there?
Respondent number 3.
Considering the above, list this matter again on 12th of December 2025. The respondent number 3 is directed to appear before the court through the video conferencing link to be provided at 10:30 a.m. through the video conferencing link to be provided by Mr. K.P. Pathak, the Standing Counsel of the APDCL. On the same date, the respondent number 3 shall apprise this court as to why the petitioner's representation have not been taken into consideration. Withdraw. Okay. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition. Mr. J. Stuart, the learned appears on behalf of the Standing Counsel of the KAC, appears before the court. Taking into account the above, the petition stands closed on withdrawal. Interim order stands agreed.
29.
Suspension order. And due to the tendency of the incident, this one already has passed order, speaking order in 2025. Putting the petition on holiday. The sealed order has already been challenged before the court authority by filing an appeal. In terms of the new police. Speaking order will get the next in our.
What order?
This is 175. There was issue.
One.
Issue on 29th of July.
Where is that?
That's page 49.
In the last order?
175. Yes, I think they have filed in the
Can't see. No. Oh, call Mr. Yes. Oh, you cannot do that, na? You cannot withdraw. Why are you withdrawing without his right? You see, tomorrow you may be in a lot of difficulties. Don't do that. Ask your senior to come. Tell Mr. Jesuti about this. Ask him to bring, call him. You have to recall that. Yes, what is this?
Case 175. In terms of losses initial order, petitioner has filed and replied. And therefore this order.
So cause notice, and then what happened?
Yes, we have written into Pasioda speaking order.
Which one?
This 170.
175. 175 is just nothing.
175. Okay. Which they have filed.
175.
10/10/2025. That's the order which is now pending, maximum period 2 years.
Order passed.
Yes. And
Then
last paragraph. So once a regular, so desired days declared active against this order within 30 days from the date of its issue as part clause 4/11 was one of the beginning policy. They already they have filed.
then why should we look?
I just said the question why. You should just read 170 for a moment, my. That is the second last paragraph of this order. The same order at page 170. So it says the undersigned the application with his mind and wisdom, and after having gone through the entire matter and documents on record and submissions made by UTPL with respect of the oil India show cause notice, it is established that United Breeding Soils has defaulted in the contract by provision for.
You are reading which page?
I'm reading minor page 178 of the order passed by Oil India Paddy. That is 10/10/2025.
Yeah, which page?
I'm reading.
Because your
178.
page is different. Because here it is 184.
I'm sorry.
184, 185, 186, 187.
I'm reading-
Okay, your page is which page you are reading?
I'm reading minor 170, the last page of the order.
Oh, yes.
I'm sorry.
Paragraph.
Yes, ma'am. The second last paragraph. it says
Does the
thus-
undersigned
Yes,
after application
yes.
of mine?
So they have, it says it is established that so and so has defaulted the contract provision by violating the provisions of integrity pact. Subsequently, it says, my lord, that United Breeding so and their allied firms are placed under holiday list of Oil India and thereby debarring them from participating against oil's future contract for the period of 2 years with effect from 29 July 2025. That order, my lord, is at page 49. The initial order was for an issue of suspension of violation in regards to an integrity clause violation. Now, these are two different steps that have been taken. There was first a suspension order that was issued on 22nd of July.
49.
Yes, ma'am. That's page 49 of my writ petition, ma'am. I'll just read one line of that, my lord, which was the writ petition that we filed and challenged.
Yes. What is it?
Yes, ma'am. The last part of that order, my lord, which is at 6.0. It says further, may I just read the permission?
Where?
My lord, this is page 49, annexure 2, my lord. I think
Yes.
the 2 pages which are missing, we filed an application to get it to come to the entire document.
Where is that?
So page 6, para number 60.
Which page?
My lord, this is page 49, A and B, because we, that 2 pages were missing when we filed the writ petition. We moved an application and got that on record.
The additional affidavit. Okay.
Yes, it's in addition, but the affidavit that we filed.
Yes. Then,
I'm sorry, that's clause is 60, ma'am.
yes.
Yes, ma'am. So it says further, oil maintains a zero tolerance policy towards corruption in view of the seriousness of the present matter and the pending the completion of the ongoing banning proceedings. You are hereby placed under suspension with immediate effect for 3 months from the date of issuance of this show cause notice, during which you shall not be eligible to carry out any business with oil or participate in any tender of the oil. Now, my lord, my proceedings, my tender is an ongoing tender. I have already participated. It was a single tender. I was allotted the work and I completed 70% of my tender of the work. In terms, before issuing this, my lord, they issued me another suspension order. That is the page, my lord. The lordship should be kind enough to come to page 89. This is the first suspension order that was issued against me. Subsequently, this order was issued 29. I read the first paragraph of the permission. With reference to the subject order and lodging the recent FIR, it is 3/5/2025, by the Central Bureau of Investigation, it has come to our notice that prima facie there has been a violation of 2(1) of the integrity pact and other provisions. Subsequently, madam, the second last paragraph says, therefore, Oil India hereby decides to suspend the delivery of materials.
But
GPL
Mr. Pukanvi,
Yes, ma'am.
that what you have challenged
Yes, ma'am.
before the court has already culminated into the final order.
That is for the banning. That is, so there are two suspensions, ma'am. One suspension is saying that you do not further act on the contract, which is the present contract, which also says that in the future you will not be allowed to take on any contracts. My problem is, ma'am, this contract I have already completed 70%, and they are yet under the integrity clause by which they have suspended me and now subsequently banned me, is yet to complete that process of violating of the integrity clause.
Where is the complete ban?
My lord, that is at page, the integrity clause, my lord, is at
No,
page.
no. This order, which is passed at page 175,
Yes, my lord.
is in pursuance to a notice dated
Which was
29/7/2025.
challenged. Yes, ma'am.
Now here you have challenged that notice dated 29/7
Yes, and 2/9.
and 2/9.
Yes, ma'am.
2/9, what has happened?
2/9, my lord, that's what I was reading, my lord. Page 89. They have said that.
No, not 2/9, 2/7.
2/7, I'm sorry, my lord. Page
Where is
89.
2/7?
Yes, ma'am. Page 89. So therefore, I'm reading the second last line of my of page 89. Therefore, Oil India Limited hereby decides to suspend the delivery of material against the contract if it's so and so for supply, installation, commissioning of the truck mountain wire which is placed on your front until further advice. So the present contract was put on a hold. Subsequently, the suspension and order that was I have challenged on 29th of July is also a show cause notice for suspension and banning under the banning policy, which also speaks about future contracts. That is page 184, my lord, is the order they have passed. So all the orders that are passed, my lord, are for the future that I have been back.
Where is that again? Yes. So you say 2/7 is separate.
Yes, ma'am, because that has to be in terms of the ongoing contract. And in that, they are saying that there's a violation of the integrity act. Integrity act is also in regards to the planning order, because it's a separate suspension which is covered and a procedure is to be followed. I can't say much on that because I have not challenged that with Usuri a deal that is pending before Oil India. But in terms of this contract, my humble submission is, if they have to further go ahead with this contract, there has to be some order passing for the contract which I have performed 70%. Integrity clause says there are two options available to you. That's at page 51 of my rate petition. If it is any agreement not signed, then the entire tender is to be scrapped. If you have signed an agreement, then it has to be terminated, because that is the violation of 2(1) under the integrity clause. But that has not happened. So 70% is what I have done, and which I have replied to this notice and said. So the present contract remains as it is. They haven't taken any step. All of them are in the future. where they have value to participate. 2 years.
Yes, what steps have you taken as regards 27? He has challenged both 29.7 and 27. Now, what have you done? You don't have a reply up here in your affidavit? Are you seeking an instruction in this regard?
This aspect is not in touch with the matter. The affidavit is
Huh?
What about the current tender? That is
And nothing else they have mentioned. About 27? Where is your statement in your repetition about 27? Yes. Here they give it, paragraph 8.
Yes.
That the deponent begs to state that as the subject, the NIT was previously found to constitute a breach of EIR, the same warranted initiation of action in terms of the banning policy. According pursuant to the decision of the competent authority of EIR, the supply order under procurement was suspended until further orders. Okay. Now, Mr. Kulta, you may suspend a supply order, but there has to be something be done. You can't keep it under suspension for long. We keep it next week. In the meantime, you give your stand, bring your stand as regards what steps are you going to take about this order dated 2/7/2000. Heard Mr. R.B. Phukan, the learned counsel, appearing on behalf of the petitioner. Mr. K. Koilta appears on behalf of the Oil India Limited. It has been submitted. It is submitted by the respondent counsel, by Mr. K. Koilta, the learned counsel, appearing on behalf of the respondent Oil India Limited, that in pursuance to the notice, show cause notice issued on 29/7/2025, the respondents have already passed an order on 10/10/2025, thereby debarring the petitioner, thereby putting the petitioner and all its allied firms under the holiday list of Oil India, of oil, for a period of 2 years with effect from 29/7/2025. It is also submitted at the bar that the petitioner thereupon have challenged the said order dated 10/10/2025 before the appellate authority in terms with clause 4.11 bracket Roman 1 of the banning policy. Mr. R.B. Phukan, the learned counsel, appearing on behalf of the petitioner, submits that by way of the instant with petition, 2 orders were specifically challenged. One was the show, 2 communications were specifically challenged. One was the communication dated, so-called notice dated 29/7/2025, which in view of the subsequent developments, the petitioner now may have to take recourse, have already taken recourse to challenge the order dated 10/10/2025 before the appellate authority. But as regards the order, communication dated 2/7/2025, whereby the respondent oil have suspended the supply of the materials, there appears to be no answer in the affidavit in opposition. Mr. K. Koilta, the learned counsel, appearing on behalf of the petition, respondent oil, submits that he may be given a week's time for submitting a further affidavit, further additional affidavit in opposition in respect to the communication dated 2/7/2025. So taking into account the above, list this matter on 16th of December 2025. In the meantime, the further additional affidavit be filed by 10th of December 2025, liberty given to the petitioner to file reply if it.
Pending item 28.
Mr. Sutia, he cannot withdraw. He is not the council because I withdraw it later on. There will be. Okay, we do one thing. You have filed the affidavit today. It is seen that the respondent number 2 and the respondent number 4 have filed an affidavit in opposition today. The council appearing on behalf of the petitioner 6 for an accommodation list the matter on 15th of December on 12th of December 2025.
Item 30.
Reply if any be filed or not before the next. What?
Second step of the here was the direction to take state project, but if you mind is to state a bit 21 of November.
You have not taken steps.
Steps have been taken on 21.
Our record says something else. Anyway, I'll send
I
that.
think allowed.
Okay. It has been submitted that the steps have been taken on 21/11/2025. To stop taking into account the above, list the matter on 2/2/2026. In the meantime, the respondents shall bring on record their stand by filing the affidavits on or before 28th of January 2026.
Submitted item 54.
Yes, what is this?
Your Lordship, the contractor fee, Your Lordship,
Why the contractual bill is going on for such a long time?
yes, yes, Your Lordship. Yeah, what happened, Your Lordship? There was a CBI case was there. And subsequently, I got executed in the official case, Your Lordship. When I submitted my representative, they say that the record are lying with the CBI. And on the last occasion, Your Lordship, on the submission, on 23/4/2025, Mr. Gino appeared.
I ordered it at 15/2/2024.
Yes.
Yes, whether the petitioner is entitled to the amount or not.
The record is not applicable for the department director. At the same time, when after searching the records of the CBI also, that's pending before the court also. Then also we failed to obtain the success of record also. And the petitioner also submitted the completion report of the work completion report also. Work completion report.
So, record, yes, see.
The CBI, we had, after verification, we had not find the report. In the reports of the CBI.
Mr. Counsel, I'll dismiss your petition. Reason is very specific. Your work order was issued in the year 1991. 1993, you said that you won the money. Thereafter, you kept quiet.
No,
Yes.
thereafter I approached the authority, they said that since
No. Those approaching the authorities for the civil court. I don't have any business out there. Thereafter, you issue a legal notice in the year 2003.
yes,
Okay.
yes,
The judgment comes in the year 2006. Judgment comes in the year 2016. Now thereupon you say that that amount should be paid.
Then-
Why on earth you 1991 to 1994 you did not file any case? How will they file any document?
Your lordship may kindly see special cases of 97,
What?
97,
What?
the case.
So what?
So I approached, they said that since all.
No. Then also you issue the legal notice.
There is,
If that be so, why what compelled you to issue the legal notice on 2003? That no case. Can't help it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent numbers.
1, 2, and 3.
All the respondents.
All the response can be.
First of, the petitioner herein has approached this court seeking a direction upon the respondent authorities to make payment of an amount of rupees 1,61,200 to the petitioner, along with adequate interest from the date of submission of the bill till the date of making payment. First of, it is relevant to take note of that the petitioner claims that a work order was issued on 28/1/1991. The petitioner further claims that that work order was issued on 28/1/1991 for carrying out various repairing works. The total value of the work order was rupees 1,61,200. The petitioner, it is a further claim of the petitioner that in the year 1993, the petitioner completed the work, but he had not received the payment. In that regard, communication was issued to the Minister, Veterinary Assam, on 25/3/1993, but the said did not meet any favorable response. The petitioner thereupon waited for another 10 years and on 14/11/2003 issued a legal notice claiming the amount of rupees, claiming a amount of rupees 1,61,200 along with interest. It is the further case of the petitioner that in the meantime, there was a criminal investigation which led to a charge sheet and registration of a case being special case number 22C/1997, renumbered as special case number 55/2004, wherein the petitioner was acquitted on the basis of a judgment and order dated 10/11/2016. It is the further case of the petitioner that pursuant to the said judgment, the petitioner issued another notice of representation on 31/10/2017, claiming the said amount of rupees 1,61,200. The said amount, however, having not been paid, the petitioner had approached this court by filing the writ petition in the year 2018. This court, Mr. J.K. Goswami, appearing on behalf of the respondent, submits that it is next to impossible on the part of the respondent authorities to carry out any verification, taking into account that the work order was issued, alleged work order was issued in the year 1991. And thereupon, the petitioner have approached this court by filing the writ petition in the year 2018. He therefore submits that any direction so passed for carrying out the verification and then to pay it to the petitioner cannot also be acted upon, cannot also be implemented in view of non-availability of the records. In addition to that, Mr. J.K. Goswami further submits that there is no materials also being placed as to whether the petitioner has completed the work in question. And under such circumstances, this is not a case where this court ought to exercise the jurisdiction under Article 2 to 6 of the Constitution. I was dismissed. It is liberty dismissed.
55.
Miss B. Bhuya, the learned senior counsel. Where is it? What is your instruction?
Lordship, our officers were smart. Instead of giving instruction to us, maybe the government advocate is very good. Lordship was like straightway have given instruction to the Malayan bench. We already filed his agreement.
Already we have filed out.
What is that affidavit?
That is, it is filed by additional chief engineer.
Huh?
Additional chief engineer.
Huh?
Response number 3. So
What does he
the
say?
name of the petitioner is reflected.
Where?
Considered this number 2.
Which page?
Considered this start from page 73.
Huh?
Drawing 73, 74. His name is reflected in serial number 1, 2, and 3.
1,
2 and 3.
page 70.
4.
Your page, my page are all different. One,
1, 2, and 3. Because paper is my
palliative measures to protect different reaches under Tamulpur so and so, isn't it?
yes, sir.
Ashutosh Chakraborty,
Name of the contractor.
work done 100%. Outstanding liabilities 4 lakh so and so, date of commencement so and so, date of completion so and so, date of submission of bill so and so, court case any so and so. Okay. Now you will get the money when? Whenever fund is available.
No, that fund will be released by the BTC authority. We have already been submitted to that also. That we have already stated before.
So you will pay as per this chronological list.
Lordship, one instruction I have received yesterday from another student. Appeal liability is 25 crores, 8,70,669.
So, Mr. Counsel, your name is there. You will get your money. You can't help it. This is the law. Hmm? This is the law. I can't give you a preference. You are there in 1, 2, and 3
Yes.
of the statement showing outstanding liability with effect from 2009-10 to 2020-21. So you are the first in the list. You get the money. Understood, but now you all facts and figures are there, so you will be getting. So I'll put an emphasis that whenever you will be the first one to get. Take he is in the serial number 1, 2, and 3. The petitioner herein heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, and Mr. R.M. Das and Ms. B. Bhuyan, the learned senior counsel, assisted by so-and-so, appears on behalf of the PTC authorities, and Mr. R.M. Das, the learned standing counsel, Water Resource Department, also appears. It is seen that pursuant to the orders passed by this court on 1/10/11/2025, an additional affidavit in opposition has been filed by the respondent number 2, that is the Chief Engineer, Water Resource Department. In the said affidavit in opposition, it is categorically admitted that the petitioner herein is entitled to an amount of rupees 9,21,842. It is also stated in the to the said affidavit in opposition, thus the consolidated chronological list have also been enclosed. It is seen that consolidated chronological list has been also enclosed. It is seen that in respect to the consolidated list 1, the total liability amount is 185,798,064, of which payment have been made in partial as well as full. In respect to the consolidated list 2, which is the subject, which is relevant for the purpose of the present case, the total outstanding liability of the BTC department is 170,075,605. It is also seen from the said consolidated list number 2 that the petitioner's name appears in serial number 1, 2, and 3. It has been also submitted that whenever payments are made from the consolidated list 2, the petitioner will be the first to receive the amounts, taking into account that the petitioner's name appears as serial numbers 1, 2, and 3. Taking into account the same to be an undertaking before this court therefore closes the instant petition with a direction that whenever the respondent authorities take steps for payment of the due liabilities in terms with the consolidated list 2, which list 2, the petitioner dues should be cleared first. Instruction placed by Ms. B. Bhuyan, the learned placed by so-and-so. Ms. B. Bhuyan, standing counsel of the BTC, is kept on record and marked with the letter X.
Item 57 to 65.
What are these?
My employer might not was the Assam Police Housing.
Assam?
Police Housing Board. There's no dispute there. The extent that additional work was required to be done in construction of this building. Now thereafter, after completion of the work, they said that we don't have budget for the same, we have to send a proposal to the Women Political Department. Women Political Department in turn, my lord, appoints the PWD to literally examine this proposals. That whether these additional work is going to be done or not. Those reports also, my lord, have issued sometime on 17th of September with the corrigendum on 15/10/2025. They have recommended the payment. Now,
Now, what happened before the special standing finance committee?
Again, I have received a letter with the earlier not sent. Again, it was sent on, these were sent on 1st of November 2025. So again, they have sent some documents which are not sent earlier. It was sent on 1st of November. So I have received the instruction today, man, of taking in the same bank that place the same into the stations that is finance committee for consideration.
Hmm?
Instruction for administrative approval, my lord. That was very our case. Because some projects were not that unfinished. For them, the revaluation of the fund. But you see this letter started referring to 1995.
You want interest also? Then go to the MSME. Why not going to the MSME Facilitation Council?
As of now, we have had a.
No, you have to give up their prayer.
We have to go ahead with the amount.
No, you are asking, this is a very dangerous prayer. This is a very dangerous prayer. This is a very difficult prayer. Because what you are asking is interest at the rate of 16%. Why should this court direct? If you want, you go to the Facilitation Council. They will pay.
Those are not fully functional.
Huh? No, fully functional. Facilitation Council is fully functional. Go there. They will have first mediation and then they will go for arbitration. And the interest, how it is to be calculated, that day I deliver the judgment, look into it and do it. Very well. Very difficult. Every month it will be taken up. This is a very dangerous prayer. Madam, you appreciate this. It looks very innocuous. Any direction given for consideration of interest will have a far reaching consequences.
Amount is too high.
Amount is too less. Madam, you are not understanding. This 50 lakhs is peanuts. The interest, it is compounded 3 times the RBI circular rate and with monthly rest. Means every month, if it is 100 rupees, if it is 27%, 21%, then it will be the 24%. Let us take a calculation, 24%. Then it will be 102 rupees on the first month.
Compounding.
102 rupees. Then the next month it is taken on 102 rupees. 102 or 120, 24 rupees, whatever you mean. It will be taken on that. So therefore, this is a very dangerous proposition. It looks very innocuous and Mr. Pathak also submits in a very innocuous manner. It looks very simple, but it is very dangerous. No. This is, I think you should file proper affidavits. Are you denying or not?
The affidavit, they have already denied the interest claim. The affidavit, they have admitted the work executed the interest claim of course matter.
Oh,
It's already.
why they have denied? Interest claim?
It's an assignment. Then there was a denial.
The reason without assigning is a different thing. But have you enclosed the certificate? MSME certificate?
One of the takes up the first notation by code 747. It is a page 29.
Page
29.
See, this is a very dangerous certificate. And they are services done in so and so real estate activities on fee. Registered when? When did you get the contract?
The contract is of 2019.
2000? See, they are there from 1994. Looks very innocuous. Later on, you may have to sell your all this garden, all this housing board. When you are paying,
That is one of
you pay out here, then I will get hold of these people and say that we are not demanding interest.
already one of that sent to the one of finance man. One letter one of Vijay Pal is a joint secretary. The one of secretary of the government of finance man of establishment department.
The implementation might not be of the earlier fund that was available that lapsed.
So they have gone for revalidation.
Now, our case was my lord for the resanction of additional amount. That my lord, the Human Constitution Department asked PWD to that, but PWD responded to the.
No, they have therefore asked.
15, 10,
Is PWD a party here?
No, my lord, but then.
Finance is also not party.
Finance is not a party.
Not a fact.
Why you are not making them a party?
Very difficult to get all of the funds.
PWD, my lord, they.
You make the finance a party. No, you have to get hold of the finance, because otherwise it will be next to impossible.
Not
If I direct also.
it's a amount is high. So that's why.
Amount is not high, but the fact is, if we
Interest.
pass an order also, they will say that we have given it to the finance and the finance is not doing.
Yes, madam. Yes, madam. Like
Ultimately, no, do it now. But ultimately, when after vacation, get to you, in the meantime, you file that application. Huh? Mr. B. Pathak, the learned counsel for the petitioner submits that the petitioner would like to add the finance department as well as the PWD department of the government of Assam, as the same departments would be relevant for the effective adjudication of the petition, taking into account these matters upon such applications being filed.
Item 66.
What is this? Vendor's license. What is your stand? Affidavit filed. Okay. It is seen that the affidavit has been filed on behalf of the respondent number. It is seen that the affidavits have been filed on behalf of the all the respondents. No? Then 3 has filed, 4 has filed, 1, 2, 3, 4. Only 5 has not filed. Okay. It is seen that the affidavit has been filed on behalf of the respondent numbers 1, 2, 3, and 4. The petitioner, however, is not present. Be that as it may, this court for the ends of justice adjourns the matter to be listed on 4th of February 2026. In the meantime, the petitioner is given the liberty to file their reply if
67.
At 2 o'clock, madam, we are supposed to file at 28, madam, as per the action of this one. Right now, madam, they have filed and stating, madam, where there is no provision for a fund, madam. But I'm very strange, madam.
there is no provision for refund. How can you approve it?
Because, my lord.
They say that there is not a mistaken collection. That is, their language is by a very cryptic, madam, Jilapi Pagnisha. That is, my lord, say therefore the same cannot be subject to the fund. Because said to be regarded as a mistaken, it cannot be taken as a mistaken, madam, collection.
Mistaken?
Collection. Yes, yes.
Connection.
Collection.
Collection.
That is the word they have used. Because they have not yet still issued my license. Till today. That's why my lord, the lordship kindly, see, this is affidavit. They have some feeling they have.
Let them file. They filed the affidavit. Na? You want to file a reply?
Yes, I want to file it.
You file a reply, we take it up and finally dispose it before vacation or after vacation.
Because he's need of money 78, 72 lakh, the money is more than 1 year.
It will be up before vacation, provided you give me the English word of what is jalebi pak, you say.
So, my lord, you're also.
Give me
I
an
am
English
submitting, my
word.
lord. Yes, all record is there. Mr. Gogoi say yes, yes. we will
No,
give it.
you
Now,
see,
my lord, they are-
Mr. Mohanto, you see, whenever the forest excise PHC councils make submissions, then don't go by what they say. Because if Mr. Bhattakur says something, Mr. Gogoi may say something else. Mr. R.R. Gogoi would not. R.R. Gogoi and Mr. Bhattakur keeps there is some standard maintained to that. But Mr. Gogoi, D. Gogoi will come up with another standard. So don't go by what they say unless you get their affidavit. So don't go by that.
So, my lord,
I have an experience out there. So don't go by what they say. Don't on that. So today, if it is there, therefore I insisted that they should file a record.
yes, my lord.
Because if they say something, I'll record it. The other person will come up. He was not supposed to say.
But that's right, right.
This is how excise, forest, and PHC happens. So therefore, we do one thing. You file your reply as he has filed an affidavit, and we'll take it up before vacation. In 16th, I'm not there. Now only I remember I'm not there on 15, 16. So, okay, let us have it on 17th. 17th. It will be a motion day on that day. But let's see at 2. It has been submitted on behalf of the excise department that an affidavit in opposition has been filed. Mr. T.J. Mohanto, the learned senior counsel, submitted that he would Mr. Miss so-and-so, the learned counsel who represents the petitioner submits that she would obtain instructions from the petitioner as to whether the petitioner would like to file a reply. List this matter on 17th of December 2025. In the meantime, if any reply is to be filed, the same be filed on or before 15th of December.
68.
Affidavit filed, PHC. What is your case?
Huge amount of murder, 53,87,899.
What do they say?
26 lakh, 20,300. So,
So they admit 26 lakhs, but deny 27. So we direct them to pay the 26 lakhs within 6 months. And as regards 27 lakhs, I give you the liberty to approach the civil court. Paragraph 5.7 to put 7 to go that last direction to this. Last of direction. Accordingly, in view of this, considering the above, the instant writ petition therefore stands disposed of with the following observations and directions. The petitioner herein is entitled to an amount of rupees 26,23,383 as have been duly admitted by the respondent authorities. The respondent number, the respondent, number 2, the respondent number, who is going to pay? 2.
If we discuss to chief engineer's office.
Chief or additional mission director. Why don't you make the chief engineer a party? What is the problem? Who is to pay? Who has filed the affidavit? Who is to pay? The payment is towards what? With the respondent numbers 1, whether it is a under the mission JJM.
Yes, my lord, most office bearers of PHE are by their office are members of the JJ. So they are holding two in charge.
No, is the amount payable from JJM or from the PHE?
Let it be PHE.
Then there is a problem. Na? Where is the work order? Where is your work order?
23 of the register.
See, this is also, again, no, I'm telling you why. Do you see? Saurabh Gora, he is the executive engineer, Hosai division. Now, tell me, Mr. Bhattacharya, I'm saying, I only come to page 15 of the petition. This very executive engineer on 16/9/2024 certifies it to be 53 lakhs. Okay. Now this affidavit is being filed by the executive engineer, who now says it is 26 lakhs. How do you reconcile? What do you say about this certificate? This is very serious. This is why I'm being continuously telling. Why you are filing the affidavit to the executive engineer? Problem arises there because here it is a conflict. This very engineer says, which is Annex B, that he is entitled to 53 lakhs. Isn't it? And the same engineer now says, no, he is entitled to 26 lakhs. How do you reconcile both?
Let the chief engineer verify.
I think you file an affidavit through the chief engineer because this is necessary. And in these PHE departments, you file the affidavit through the chief engineer. Because why it is necessary? Because mostly the problem is because of the executive engineer. This is also a matter of this file. These are, see, look here, these are work orders of 2015. See. Let's see, Annex 3, page 14. Work orders of 2015. On the left hand side.
Start from 15.
So this is how they give it. It is seen, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. I. Bhattacharya appears on behalf of the respondent PHE. Pursuant to the directions passed by this court on 19/11/2025, an affidavit in opposition has been filed on behalf of the PHE department. It is seen that the affidavit in opposition has been filed by the executive engineer, Hosai division, wherein at paragraph number 7 it is mentioned that the petitioner is only entitled to 26,23,383. And not entitled, and there is a denial to the amount of rupees 27,34,506. However, the same officer, the same office have certified a liability statement, which is annexure 3 to the writ petition, wherein it is mentioned that the petitioner is entitled to rupees 53,57,899. Under such circumstances, this court therefore directs the chief engineer, PHE department, to file an affidavit in respect to this and explain this discrepancy. This matter on 18th of December 2025, the affidavit in the meantime be filed by 15th.
59.
See, what is your case? Certain payments, but there is a balance amount of year. What do they say?
Basically, as model code of conduct was in place, limited period of contract. It was calculated pro rata basis and as it was indexed for 90 days, I have to pay on 90 days.
As per is now payable for 71,000.
So they have received the money.
That amount we have received. That amount 71 lakhs we have received for 90 days.
What is left?
Virtual can come to case 43, that is the work order. Scope of the work was for disturbing for 30 days. Subject harbor only they have stated in the work order. It has to be removed when model code of conduct is in place. There is nothing mentioned as to what will happen if it comes in place, only to remove. With regard to payment on pro rata basis was not given any details.
Therefore,
So
the
we have-
total amount payable after necessary deductions to that rupees so and so, as per the calculations made. The answer is back to state that a payment of rupees 45 was made on so and so. Further, an amount of rupees was paid in so and so. Therefore, total paid. You are not
That will come
entitled.
to the work order.
Huh?
Work order was of 99 lakhs. The certain holdings were to be displayed.
Now, what do you want?
The remaining payment for the 11 days, they have deducted that amount. So work order doesn't specify as to.
And commission was there, madam.
No condition, Mr. Counsel. They admit to only amount of rupees 71 lakhs. And they say we have paid you. Anything more, you have to go to the civil court. I can't help you. How can I help you more than that? You got an answer quickly. 2025 writ petition so early. Okay. So remaining is 30 lakhs.
That is what our because we have.
30 lakhs, if you are there, they dispute that.
Madam,
They dispute the people. Logic can come to work order.
No, understood, but how can I pass an order as regards how much you are entitled to? Problem arises there.
But the question is not exactly the entitlement, but with regard to the period for what I be entitled. Is it for the whole month of the work that was allotted? But so can come to place 43, that is the work order.
Where is your prayer that you are entitled from this period to other period? You have asked for money, Mr. Counsel, 30 lakhs. Then that is not a question before this court. They say that total amount what is there had submitted a bill of 99 lakhs. However, it is found that so and so failed to submit the completions and thereby leading to deduction of rupees so and so. Then, in other words, you have only, after deduction, you were entitled to 71 lakhs and this amount has been paid. So, we cannot look into this. You file your reply. Take for 2 months, I may not sit in this bench. Okay. An affidavit in opposition has been filed by respondent number 2, wherein it is being mentioned that the petitioner is not entitled to any further amount in as much as the petitioner have been paid its dues to the extent of rupees 71,53,174. It is, however, the learned counsel appearing on behalf of the petitioner, however, submits that he would like to file a reply. List this matter on 2nd of March 2026. In the meantime, the reply be filed.
Orders item 31.
What is this?
Not been provided logistics security services to the Jorhat Medical College.
Yeah.
Thereafter, logistics passed the order, which order for passed the order to clear the business. Thereafter, logistics also they have not cleared the business. The affidavit in opposition logistics, they say that EPF contribution was not made by us, therefore they are not clearing the business.
Yes, what is your claim?
Logistics, maybe please to come to the affidavit in reply manner.
No, what is, you see, what is the direction of
Yes.
5/1/2021?
Yes, sir.
What is the direction? The pending bills of the petitioner up to Iman as stated by Mr. Yas shall be processed and brought to its finality.
Yes, Lord.
Has it been done?
No, it's not been done.
Okay. As regards the claim of extension, you shall submit a representation, they shall pass a reason order.
Nothing on the claim of extension. That has elapsed.
Now, what do you want?
My, with regard to my claim of remaining payment.
Okay. So remaining payment has not been made.
Not been made.
How much is the payment?
Maybe please to come to my affidavit in reply.
No. What is the payment? How can this order be complied with? Tell me. The pending bills of the petitioner up to so and so as stated by Mr. B. Gogoi shall be processed and brought to a finality. Then
Please to come to there.
this order is not complied, cannot be complied with. Can't help you. Can it be complied with? No. Very vague. Very vague. It can be disposed of in the following terms. If any representation is submitted, reason order be passed. Reason disposed. With due respect, greatest respect. This cannot be complied with. Very difficult.
May I request your notice please come to their affidavit in reply.
No, affidavit reply has no business of it. The question is, how can this order be complied with? Tell me, what is the amount? What did Mr. B. Gogoi say?
Yes, Doctor.
No, what did Mr. B. Gogoi say? Because not a single word is there. What is the amount?
Yes, Doctor. Mr. B. Gogoi, Doctor. He said, in what he has said is there in paragraph 2. Where is paragraph?
The first grievance of the is that some dues of the EMI has not been paid. Mr. Gogoi says so and so the petitioner has been paid up to so and so, remaining up to EMI, his dues are being processed and would be paid shortly.
Doctor.
What is the amount?
Now, Doctor, please to turn to their affidavit in reply.
Yes.
Affidavit in reply at page 21. They agree, Doctor. It is their affidavit in which they agree that the bill of November and December total amounting to rupees 19,47,400. This they are agreeing. The total bill amount is more than that. This amount also has not been paid.
You are asking, Mr. Counsel, you are asking this court to again act as a writ petition. Very difficult. This is a question of contempt. It's very difficult. You see, the order which is being passed is very vague, with due respect. I may pass an order to that effect, giving you liberty to again approach the writ petition or not. This order cannot be complied with. Very difficult. Can it be complied with? No.
Let it not be taken in a very adversarial manner.
Regarding what?
Let the learned counsel obtain instructions if they are ready to pay the bill. If they are ready to pay the bill, I'll
Why you are not paying?
I'm asking bills for November and December 2020. It is payment due to non-submission of proper bill supported by payment details of ESIC, GTL transaction.
Process and brought to its finality. Now the finality cannot be received taking into account you have not submitted the documents.
It has been submitted in the manner,
Immature.
And
in the same manner that it has been submitted
the
earlier.
order under the court order dated 27/8/24, court is directed to submit.
No, this, we are not in liquidation. Okay, give me, you have mentioned that. Why you have not paid in your affidavit?
Yes, Lord.
Where?
In my affidavit, there are 7.
Where 7? Close it on that basis.
Submit
Okay. Okay, paragraph 5.
Paragraph 7.
Paragraph 5?
Yes, Lord. Paragraph 5 is here contributions. On Nevernos, they have to pay these contributions online and submit a page.
No, art, Mr. So and so. This is the, or an adjournment of the 6 months.
Sorry,
Either take an adjournment of the 6 months.
but it will fix it on,
No, if I am there, I am going to dismiss.
but it will fix it whenever, not the month of, when,
Okay.
so whenever.
At the request of the learned counsel for the petitioner, list the matter again on 4th of May 2026.
The next, that they come.
Absolutely no. This order cannot be complied with. Don't mind. This order cannot be complied with. We cannot do it. Yes, what is this? No affidavit has been received. File.
Within the field, that's what transparently, they will find out we- because secretary has filed an affidavit, still thing is 165, 166. This
The affidavit has not come on record. Vicky. Affidavit to be filed imposed by us not received. When did you file? It has been submitted by Mr. Asbora appearing on behalf of Mr. Akasdeep, na? The then Principal Secretary PTC, that an affidavit had been filed on 27/11/2025. The respondents, the registry shall bring on record the same. This is all same, na? That day also last শনিবারে কেইটামান matter আছে শুক্ৰবাৰৰ চকচোন শুক্ৰবাৰে বহুত কেইটা matter আছিল. I listed it on a particular date, same date. Last শুক্ৰবাৰৰ লিষ্টখনত চকচোন. All BTC. RB Bora was appearing. 6টা matter একেলগে আছে. 692, 693 এনেকে. আছে শুক্ৰবাৰৰ লিষ্টখন. Yeah, 692. You would give the 21/1.
and 34.
Read this.
Compliance of the order.
Huh? Have you filed your reply? Submitted by the learned counsel on behalf of that taking into account the stand which has been taken in the affidavit, the petitioner would like to file a reply. Have you filed your reply? Okay. 6 weeks time granted to the petitioner. These are the very for filing reply.
35.
No substitution. What is this? Who died? When?
It's on 5/9/2025.
What IA?
It's for substitution of
Huh?
phone number 13.
Okay. When did you file?
It's on 5/9/2025.
That IA has not come. Okay, it has been submitted that the substitution application has been filed. However, the same is not listed. Taking into account the above, the registry shall list the instant matter along with the interlocutory application being IA number.
It's IA number is 11708/25.
So many. 117085 number. No,
Filing
no,
number.
not filing number.
Actually, I didn't.
Along with the IA, bearing filing number 11708/2025.
36.
Yes, you have not filed your reply. Are you going to file your reply or not? Okay. 6 weeks time granted to file reply.
37.
Have you filed your reply? Short? Okay. In that matter, I have asked them to person of them to appear. I have also put it up that if you receive your instruction, then he need not appear. Okay. Okay, short instructions. We'll have it on Friday. Okay, so you need a short time, and I mean you need a short time. Okay.
After 2 weeks, after.
Why?
After a week.
Contempt matter? What is a contempt matter about? Contempt of what? Because
Affidavit has been filed earlier.
what is the direction? Let us see. Oh, this one.
That some funds are awaited by the council after.
Why you are not filing an affidavit? Now you may get it. Earlier, BTC administration was going against this order. 15 November 2021. This was okay. A final opportunity is given to the respondent number 1 to bring on record its stand by filing the affidavit to list this matter on 21st of January 2026. It is observed if no affidavit is filed, this court may be constrained to pass appropriate directions for personal appearance. This is not video conferencing, huh? Contempt, direct, face to face.
38.
Contractor letter when the 2 more direction was first is to release the earnest money, second is to convert the.
What? Item number 38. What is this? Currently submitted the receipt for the purpose of making payment to the person.
I have taken instruction. Even if the case is in future.
As per my instruction, madam, I have that. If it was ready, madam, that some wrong in it, because I have an extra, I find by now, so one madam by tomorrow. But my instruction is that, madam, except the total amount as per our calculation, madam, you will get 9,54,687, and out of that, madam, only 1,61,521 payment due to technical problem, and waste amount have already been credited to his account. So,
You file your affidavit.
madam, by tomorrow I'll file it.
Miss Yudas, the learned counsel appearing on behalf of the respondent number 2 and 3, submits that she has already received the instructions and will be filing the affidavit tomorrow. List this matter on 18th of December 2025. In the meantime, the affidavit be filed on or before 17th.
Madam,
Item 39 to 43.
Let her
tomorrow
file.
I'll file it. It's
In the meantime, if you want to file it, file it.
Two dice was when the contract to happen, one to release the arrest money, and second point is you want to verify the date. Now, last question there to explain that, so for the arrest money is concerned, they have communicated with the bank. Then we approach the bank says that no such communication was received. So we can't see affidavit reply. Very tragic. Very tragic.
He carried out the verification.
Verification,
He's entitled to.
some earlier running bills was there, only that before instituting the rate only that was given. Otherwise, my lord, most of our academic says that no work was done, so no pending bill was in favor of the bill.
It is totally a wrong submission because my lord, the.
Anyways, have you filed your affidavits?
Affidavits filed.
What did you send?
One, we have said that we have already intimated the bank that money deposit needs to be released. And paragraph 6.
Paragraph 5.
5.
So that has been released now.
No, nothing has been released.
Have you made the bank a party?
So my lord, bank, because my lord, in contempt proceeding, there is no direction to the bank. My lord, what happened, there is a direction.
No, if they have already issued it to the bank as per Annexure A to the chief engineer, so and so, Iman, information regarding Iman. Have you informed to the bank?
My lord, as far as the bank is concerned, my lord, they have informed to the bank about the release of the money. It is their step.
Where is the document?
My lord, affidavit reply.
No. Where is the document? You don't, you called up telephonically.
No, but in the document.
Where?
Page 36.
Our affidavit, my lord, we have annexed those in communication.
Where?
Page 27, annexure A,
To whom have you informed?
our branch manager.
Where?
In
What is the position will be clear, my lord, about the communication.
Wait now. I have known it.
I annex every document.
Where?
in 447, my lord.
What 447? All these are same petitioner. I could see an affidavit which has been filed in 437. There you are, it is to the chief engineer by the additional chief engineer, nothing to the bank.
I don't know, affidavit, I responded.
I've seen the respondent's affidavit. That is what I'm saying. Where is that communication?
Communication is an annex
To
the branch manager from the office of additional chief.
regarding
Release of.
why you have not enclosed it in this contempt petition? It is not here. What is the date?
Date of the letter is 14/5/2020. All the academics have there.
Entire document of their supply matter. I will put it in that clear the what communication they met to the bank and chief.
Page 36.
Yes, my affidavit, page 35.
Now the bank is not releasing it.
Because my bank stand is that they have not received any such communication. That's why the affidavit reply just for one.
Where is the receipt of this communication from the bank? You want this, huh?
Yes, first.
You send it how? The additional chief engineer Upper Assam, PHE Upper Assam Zone, Nagaon, shall produce before this court by way of an affidavit the date on which the communication dated 14/5/2022 have been served upon the branch manager, Canara Bank, and the proof thereof. This matter on 17th of December 2025. The reports shall also be produced in respect to that.
They are standing the application position is that they have verified the bill, madam, and we have not submitted any bill in respect of that. Madam, dispose of requisition call for madam, that entire documents are there, but to verify the position that we have submitted, everything is there, madam. Let me help you educate that.
Mr. Samaya, we can only look into it when they have categorically stated that there is nothing. That is a different thing. You have to go to the civil court for that. But as regards the other amounts that they have intimated, I can look into that.
But that's
Mr. Samaria, this is not the scope of the contempt.
quite right. But verification, madam, they have to satisfy this one, what verification they have done. In court. That's the records is
If
required.
they say that no, you don't get a single penny, you therefore have to prove this court. We do one thing, these elections are coming now. I will ask the Chief Justice to give me some matters of election commission, then I can keep your matter. If there is an election petition given to me, and hold you out there. Okay, not till now.
44.
What is this?
The financial sector proposal for 1.14 has been submitted on 29/11. And it is the executive director for 8/9.
Whatever. How much is the amount?
So we found according to us, the amount paid is 1,38 lakhs.
Okay, now have you made the payment on?
Yes, sir. For 1,20 lakhs, the financial sanction proposal has been submitted on 29.
Your financial proposal, I don't believe. The financial proposal, has it been given or not?
Yes, sir.
Money we have got.
Page number 30.
Money we have got.
It has to be credited in somebody's account.
So page number 37, they have submitted on 29/11. Some time will be, but it will be.
Christmas with this money? We get an update on whether on by the 12th of December, give us an update as to whether the amount has been credited. Do you have the bank account details of the patient?
Yes, no, this is mentioned already. Page number 38. Page 38.
Page number?
38. 38.
Oh, it is there. Chalo. It has been submitted and an affidavit has been filed on behalf of the respondent number 3, wherein it has been mentioned that an amount of rupees 120 lakhs have been approved for payment of the pending liabilities of the petitioner. In that regard, a financial sanction proposal have also been submitted on 29/11/2025. And the matter had been intimated to the political B department of the government of Assam. List this matter on 17th of December 2025. On the same date, an update be given as to whether the amount had been credited to the bank account of the petitioner as is reflected at page number 38 of the affidavit filed by the respondent number 3 today.
45.
filed an affidavit for the material to trade.
You filed,
They have filed.
or everybody is appearing?
Yes, sir. I hope.
All are appearing?
I am preparing for respondent number 5.
Who is appearing for 6? What is the matter about? You are appearing, who is appearing for 5?
Not sure I am preparing for
So you can appear for 6 also. Same thing. Okay. Service being complete. List the matter. You are appearing for? Miss Yudas, except appears on behalf of respondent numbers 1, 2. Mr. A. Solia appears on behalf of the respondent number 3. Miss, who appears for 4? Mr. So-and-so appears for 5, 4, and Mr. So-and-so appears for 5 and 6. Taking into account the service is complete, list the matter for admission on February 4th, 2026. In the meantime, the respondents are directed to bring on record their stand by filing the affidavit as to whether the petitioner is entitled to the amount as claimed. The affidavit be filed on or before 29th of January 2026.
46.
Two irrigation project was allocated for the 7-8.
What is the matter about?
Two irrigation project was allocated to me by 30 members of the council. And I have completed the work in 2011. And thereafter, they have not paid the amount.
Why the matter has come up today?
For audit, it has come.
46, na? Okay. Okay. List the matter again on payment of dues. 28/1/2026. On which date an attempt shall be made to this for admission, on which date an attempt shall be made to dispose of the
47.
You file your reply? Okay. 6 weeks time granted for filing the reply.
48.
You want to file reply? 6 weeks time granted for filing reply.
49.
You file affidavit. What is the direction passed? Amsar Ali. How do you apply Amsar Ali in? You are putting him in a chronological list. You don't have a chronological list.
Officially, madam, we don't have. but-
Then how is this order can be complied with? This is a different difficulty. Amsar Ali, I think, is in only BTC and PWD. Others they don't have. Now, what is there towards the authority? Okay. Anything, any development has happened? Paragraph 5.
After that, I got clear that what yet minority
Mr. I. Bhattakul, the General Counsel appearing on behalf of the PHA department shall apprise this court as to whether any further steps as regards an update to the financial proposal dated 11/6/2025, reference to which is in paragraph number 5 of the affidavit filed by the respondents. Is the matter on 30/1/2026.
50,
Yeah, you know, comparing the contextual use method, they responded and filed their affidavit method.
They filed.
They have filed. They have bring on record the chronological list method. My serial number is.
Where is the affidavit? You have it. It is been submitted that the respondent number 1 and 2 have filed an affidavit in opposition. List the matter again on 10th of December 2025. In the meantime, the registry on the next day, the registry shall ensure that the affidavit of the respondent number 1 and 2 is on record.
I'm the clue.
if you are
Other ones,
Mr. B. Gogoi, the learned counsel, appearing on behalf of the respondent. 6 weeks, 1 month's time. Submits that Mr. B. Gogoi, the learned additional advocate general, submits that the respondents have sought for 1 month's time for finalization of the matter. In that regard, he has placed an instruction which is kept on record and marked with the letter X. Mr. Matter again on 28/1/2026. The respondents shall take every steps for due compliance on or before the next date. You finish it off, huh?
70,
Huh?
70.
70. None matter. What is this? We don't see you nowadays, or you are busy in bench 5. Never seen you. Fisherman, 100% fisherman. Yes, cooperative society. Yes, this is a case where the cooperative society was directed to make certain inquiries, isn't it? Whether the rule 48 has been amended. Oh, this one, yes, yes.
Last order, directed to the inspection.
This is a very, very interesting case. At the time when the repetition was moved, it looked, at the first glance, it was looking very innocuous. I am number 6 and number 1 doesn't have 100% fishermen, so therefore the court should reject it. Then if you look further, then you see number 2 came. Number 1's quote is something like 92 lakhs, if I'm not wrong. Number 2 came. Number 2 has 68 or 70 lakhs. He got that order from the brother Michael Jothankumar to make a verification as to whether it is 100%. Then 2, 3, 4, and 5 left the scene. Now comes 6, who quotes only 42. Yes, what is the instruction?
The instruction, the inquiry was made pursuant to the order in the earlier round of litigation. The order was 4625. The inquiry says the respondent number 6 society is comprised of fishermen community.
100%.
Yes. It does not say
You being on record the same
correct.
by filing an affidavit. Mr. S.K. Talukdar appears on behalf of the Corporation Department and submits that pursuant to the order passed by this court on 4/6/2025 in WPC number 3094/2025, an inquiry was conducted and it was found that the respondent number 6 is a fishermen's society. Is a society comprising of 100% fishermen.
It does not say, madam, that it says that allegations are, madam, false, on basis.
100% fishermen. And the allegations were made by the petitioner are not correct. So it is the opinion of this court that the said aspect be brought on record by filing an affidavit. Full stop. This matter again on how much time? Okay, this matter again on 18th of December 2025. In the meantime, the affidavit be filed on or before 16th December, along with such report. Huh? What hearing? Which hearing? What hearing?
So in the hearing matter, I am required to give the instruction as regard connection of the Assam Industrial Employment Standing Order Assessment Rules 2025. I will-
What is that matter? See? What that matter?
Yes, I have received an instruction.
Or draft rules, industrial. What is happening?
No, they said that they have already,
It should have been, it's a part of matter on corporation.
they have put up it for an approval, but it taking them before labor codes were 45 on 21/11.
So the code of wages have come in
So
from
yes,
21st of November.
yes, we were on 21/11, this was the notification. And now they have to prepare the state rules.
And that is a different thing. Till you prepare the state rules, that will go on. But why you are not making the draft this thing?
But yes, as per the total tenure of this.
Whether it is subsumed or not, that we'll consider later on.
But the-
You see, there are many things. Those code of wages rules may have many other aspects. We are concerned about the standing orders for these. These are for under the Industrial Relations Code 2020. Whether this aspect will be brought within it.
in detail, I have not seen, but going by
No,
this,
if it is not, the reason why I'm saying, then in that regard, I proceed with the disposal of the requisition.
particularly this restriction.
No, why I'm saying I kept this only for the purpose of putting the pressure out there. But if it is not so, I can go ahead. It's no problem for me. I only wanted this matter to be kept for time. What has happened out here, if I remember correctly, out here, these persons were 65 or 70. But they were therefore asked that, okay, you are out. Their basic case out here is, look here. Their case is, look here. There's no standing orders. So under such circumstances, there's no, in our certificate, there is no age given. So how can they do so? Therefore, their case is to the effect, if I remember correctly, this is the case. But I kept it out here because it was stagnant for all this time only in Assam. This is happening. And this is a big problem which was happening. So just find it out, because if that be so, it will have a far-reaching consequences, because then let me proceed with it. When can you get, you have a look, have you made the Industrial Relations Code? Any draft? Just find it out. Let us have it after vacation. And list this matter at the top of the list. This is a very old matter. List this matter on 21/2026. Showing it as at the top of the list, showing it as parted. On the next day, the Labour Department of the Government of Assam shall apprise this court as to whether the department would be going ahead with the industrial employment bracket standing orders with the Assam Industrial Employment bracket Standing Amendment Rules 2025 or not. Full stop. Depending upon the said submission, the said stand, this court shall take up the matter for final hearing, final disposal on that date.